Live stream? Good, we're all ready to go. Okay, good evening, everyone. Welcome to the rescheduled September 2nd meeting. So this is the September 23rd Zoning Board of Appeals of the Village of Mamaroneck. Before we begin our public hearings, I wanted to give you a couple of updates or changes on the agenda. Case 5/8/2021, which is here twice, but it isn't there twice. So 413 Soundview, as well as 518 Florence Street, which both have the same case number on the agenda, but are not the same application, as well as 3/8/2021, 732 The Parkway, and 21 SP 2019, 690 Mamaroneck Avenue. All of those were discussed at the last meeting and were voted on, so there will be no discussion of those applications today. They have already been voted on. Also, with respect to 504 The Parkway, it says that the board will consider reopening the public hearing, but that was done at the July 22nd public hearing, and the board determined not to reopen the public hearing, so that will not be discussed tonight. Instead, we will discuss a draft resolution. Okay, the news has gotten better. The rain is hopefully not going to be as bad as it was predicted to be, and we won't have another flood. Okay, so the first item on the agenda is case number 4/8/2021, 1043 Boston Post Road. It's an application for a variance. Is the applicant here?
And would the applicant, yes, raise your hand. Thank you. I see. I'm going to promote you to panelist.
Greta, what did you say?
Can you hear us, Greta?
How many fingers do we have up?
I'm here. Okay.
You're not on video, just.
Yeah, I had to step out.
No, that's okay. I just wanted to make sure you didn't think you were.
You can't keep warm by keeping your name on there.
And I see some other raised hands, but I'm not sure if they are.
Yeah.
applicants.
Andrew, that you have on the applicant I assume is here. Is he the one who's got his?
We have all members. If we could have them elevated. I'm sorry. We have a new village planner. I'm sorry. My name's Andrew Spads. I don't know.
Hi, my name's Madeline Homer.
I should have introduced her.
sorry.
So.
If I could just, congratulations, by the way. Welcome to the Village of Mamaroneck. If I could just ask that several individuals be elevated, that would be Kristen Wilson.
Mhm.
We have Dennis, Joe, Brian, and Nick. If you need their first names, I will.
Joseph Dushy, is that?
I'm sorry.
Joseph Dushy, is that Joe?
I don't know what name. I don't know what email he's using.
Let's see if I promoted everybody who is.
Okay, so if you're on the job team, raise your hand and you'll be promoted.
Thank you.
Correct. It should be Joe Duche or Tushy. Do you have him there?
Got it.
Maybe
He's here.
Yeah, he is. Okay, great.
Chair, if I could just ask Robin, this was kept open? We've heard this many times. Was there something specific this was kept open for, as I don't recall?
Hello, sorry. It's Duche.
Sorry about that.
No problem, no problem.
It's a good question, Dave, and there was something specific we kept it open for. And maybe Andrew can remind us of what that was. Hopefully. And the applicant, there was something specific, Dave.
Yeah.
Good evening, Chair, members of the zoning board. Andrew Spatz on behalf of the applicant. And before I even begin tonight, thank you for actually rescheduling this meeting. I know back on September 2nd, we were in very challenging times. Our village had catastrophic damage and destruction. And the fact that we're here this evening means that we are ready to rebuild and go forward as a community. So Chair, members of the zoning board, our new village planner, thank you, because this means a lot and it's so important for our community to get back on the right track. Chair, to answer your question, there was a few little minor points on the site plan that the board had asked for. Specifically, I think there were 3 labels that needed to be added to the plans for clarification in terms of parking. I know that our team did exactly that and timely submitted it through Amber, and hopefully you were in receipt of that back before, well in advance of the September 2nd meeting.
Yes, I remember. We considered whether to close it and just leave it open to get those submittal, and then we thought we'd leave it open in case any of the board members had
Right.
questions.
This evening,
So that's that site plan or that survey with
Yeah,
the
it was
plans that we received in September, correct?
It was the site plan. Yeah, whatever that was. Yeah.
and this evening, if I could, basically, we're here seeking permission to operate a restaurant with car service pursuant to Article 6, Section 342, 30A1E, Article 10, Section 342, 67, and Section 342, 3B12, and 342, 3B85 of the Village Code. In addition,
Excuse me a second, Andrew. I'm sorry, but because we always have, our meetings tend to last a while. Please, we've all heard the application. We know what you're here for. Limit it to, informing us what's changed, or
nothing's changed. Absolutely nothing's changed other than what we discussed at the previous meeting.
can
which
you go through that?
was on the site plan. You have that. It's a restaurant car service, 2 variances, one for the parking within 4 feet of the side yard, and the other one for a space located 50 feet off the front line. Simple as that.
And can you just show us, can someone from your team show us on the site plan exactly what the changes that were made in response to the request?
We certainly can, Ralph, or if you could. Great, wonderful.
Sharing my screen right now. And we actually highlighted the areas in red.
Yep.
That was specifically requested to show the parking and the dimensions for the 2 car service spaces, to highlight the parking space in the front and the sign that was going to be used here.
Okay.
Does anybody on the board have, before I go, does anybody else from the applicant team want to say anything about this application before we go to questions from the board members?
You also, were there also, I see, on the two different plans you have markings. Okay. No.
I'm only showing you the one plan. I didn't, because this is the most comprehensive one.
It has all of the
Right.
pieces.
Do you want me to stop sharing?
No, that's fine. I just wondered if anybody else on the team had anything to add. If not, board members, anyone have questions, please?
Generally speaking, usually the variances run with the land. Maybe this is for council, but what happens if in the future they don't want to use, assuming that it was approved, and they had the car service and they don't want to use it, where does those spaces revert to?
I think if they didn't want to use them as car service, since we're approving it and it's going to be conditioned on these development in accordance with the site plan, and the site plan shows this is how it's been developed with the X number of car service, they would have to come back to amend the variance.
Or could we put in that or would they be accepting of the idea that if car service was not utilized, those spaces would be used for customers and the public,
For parking, we could do that. We could just say, and if they
yeah.
stop using car service, we could absolutely put that as a condition.
Okay.
And Chair, we're very fortunate that we have a surplus of parking. So thankfully, those 3 spots, the application itself on its face is not dependent upon maintaining those. So it would be at the discretion of the zoning board. If you would like us to keep them as regular spots, that's fine. If you want them removed, that can also be achieved without compromising the number of spots that we have.
Okay.
Well, I think that keeping them since there's been some concern raised about parking spaces, it might make the most sense to turn them into parking spaces.
We certainly defer to the board. We have no problem.
Okay. Anybody else have any questions? Meg?
I have a question, and it's not about the site plan, so you don't need to keep sharing if it's maybe a little easier for us to look at each other without sharing the site plan. We had an excellent presentation of your plans for using your software and the algorithms and the ordering. And I know that we questioned quite a bit. What percentage did you think was going to be picked up at the window? How much takeout and how much eat in? And I went back and reviewed the video actually. And I do see that we were told that you assume it was about a third. It's hard to know because I know this is a new model for you, but you're assuming about a third will be eating in. So after getting that information, I went back and looked at the code closely. And I would like to ask, I know it was in the original application, which is now we're into another application actually, but in that first one, Mr. Spatz, I think you went through all the definitions of, where this fits. It's not fast food, and now you're saying that it's a restaurant. But I would like to ask, when I look at the definition for restaurant, carryout, a carryout restaurant in defined terms 342-3, why this is not a carryout restaurant? Because that definition certainly seems to describe exactly what your model is here. And I'm sorry if other CHOP members who are here, you don't get a chance to look at our zoning code. I could read parts of it. It's based on a business enterprise primarily engaged in the retail sale of food or beverages for consumption off the premises, but which also includes the incidental sale of ready-to-consume food and beverages from a counter-type installation for consumption on the premises, provided that the area devoted to customer seating is clearly accessory to the main business and compliance with the area requirements. So as I see it, incidental sales, the smaller portion of the sales are the eat-in portion, and that the primary purpose is the ready-to-consume food that will be taken to be consumed off-site. So then when I go to the definition of restaurant, it seems to entertain already and be prepared for the fact that a food establishment might have more than one type of food establishment working in it. It says the term restaurant does not include a business whose principal operation is as a bar, cabaret, carry-out restaurant, delicatessen, or fast food restaurant. So it seems to understand that we don't have to make an either or. It could be proportional. You could have some portion of your restaurant, of your food establishment, operating as to how we define restaurant, meaning you're bringing the food after it's been ordered. A wait person is bringing it to the table. But we're very clear last time we met that would be a third of your business, and that 2/3 of your business would be the carry-out restaurant. So if you have some response, otherwise to me, I think this carry-out restaurant exactly fits the description of your business, and restaurant does not.
Ms. Jurgen, I'm going to defer to the definition as provided by the village code, which states a business is engaged in the preparation and sale of food and beverages selected by patrons seated at a table or counter, served by a waiter or waitress, and consumed on the premises.
And the next sentence.
And just if I may, and the application that was submitted went into great length and detail explaining why Chopped was a restaurant and why we felt it does indeed fit the criteria of village code. And I can read it verbatim if you would like. It's on
You stopped in your definition of a restaurant. You didn't read the full definition.
Well, the term restaurant does not include a business whose principal operation is a bar. We're not a bar. We're not a cabaret. We're not carry out. We're not exclusively a carry out restaurant.
Okay, so I would ask you, so let's go back and ask, why are you not considered a carry out restaurant when you look at the definition of carry out restaurant? Tell me what part of that, what you've described to me as your business model doesn't fit in what that definition is.
I actually can answer. I don't think that it fits within the carry out definition. A business enterprise primarily engaged in the retail sale of food or beverages, which may include grocery items. They don't include grocery items for consumption off the premises, so we have a certain amount of that, but which was also includes the incidental sale of ready-to-consume food. This is not ready-to-consume food. Ready-to-consume food does not include something that's being prepared, just like all food at a restaurant, when it's served, is ready to consume. Ready-to-consume food for a carry-out restaurant is presumably not something that is brought to your table by a waitress. And it says ready-to-consume food from a counter type installation. They're talking about restaurant service. Therefore, it is not a counter type installation. Therefore, it does not fit within the definition of carry out. Moreover, provided that the area devoted to customer seating is clearly accessory, if you look at the footprint of the restaurant, more of the space is devoted to customer seating than to any other use. So I don't think it fits within the definition of restaurant carryout. Now, am I saying that I know what it is? No, but am I saying that I don't think it's a carryout? I think very clearly it doesn't fit within the definition of restaurant carryout.
If I could respond to that.
And if
And if I could just respond right now, I'm very sorry. And then I'm sure you want to speak. Let me just respond right now. A third of the business will be eat in. So whether or not you say the footprint, it doesn't talk about the footprint. The primary purpose is to take the food off site. I do believe you are not selling any food that is not ready to be consumed. All of the food orders will be ready to be consumed, food. So you're not selling something that you have to put together later at home or that you couldn't eat. It's ready to be consumed, orders. So let me just finish. So I just disagree, Robin, with what you just said. Everything, yes, all restaurants have ready to consume food. I agree. Also, it's about the primary operation. They told us that a third would be eating in. So I know there's a great number of tables. That's wonderful. But it's not the primary purpose. As many tables as they have, they believe 2/3 of the orders will be taken out to be consumed. And also, it just simply needs to offer a counter type installation. It does offer, you can go to the counter and order your food. So it offers a counter type installation. It may also offer restaurant, just as in the definition of restaurant, where it says a restaurant, you could have a component that is a restaurant, just like you could have a component that's a bar or a cabaret, but it wasn't. The important part is what is the primary use. And as the primary use is 2/3 of the orders are to be taken and eaten off the premises, then that is a carryout restaurant.
Actually, I don't think that's right. I don't think that's right at all, because actually the definition of carryout does not say you can have can also include a restaurant use. It specifically says the only thing a carryout restaurant is. You are correct about the point that the principal purpose is carryout. Ready to consume food, all restaurants provide ready to consume food. So it clearly doesn't apply either to this or to anything else. It doesn't distinguish one type of restaurant from another. Every restaurant, the food that you're given, except, Hello Fresh, when it delivers to you, is not ready to consume.
But if you look at the definition,
let me finish, Meg. All food that is given is ready to consume. So then we look at the other pieces of this. So what can it do? It also includes the incidental sale of ready to consume food and beverages from a counter type installation. That's the only thing it can have. Doesn't say it can have a restaurant operation here. That is not in the definition of carryout. And just because the definition of restaurant allows you to have carryout as part of it, doesn't mean that a carryout allows you to have restaurant. It is definitely not in the definition. And then it doesn't talk about that the principal purpose is this. It says the area devoted to customer seating. Okay, is clearly accessory.
No,
now, let me finish. The area devoted to customer seating is principally the entire restaurant, or most of the physical space in the restaurant, except for where they make the salads. Now, they don't know what this is going to be. They are estimating 1/3. It could be 10%. It could be 80%. The bottom line is we don't know. Now, we can, so I don't know.
If I could just.
If I could just, Madam Chair?
Okay.
This sounds more like deliberations. I mean, I think if the applicant wants to finish, and then these are topics that you can talk about, I would think.
That's fine.
I wanted
That's
to.
fine, Dave.
I mean, I don't know, I'm just suggesting that because I mean,
Right.
you're raising good
I
points.
wanted to raise this and make sure that the applicant understood what I was asking about and where my head is going. So if you would like, we should ask the applicant if they would like to respond.
I would, and I'm going to allow Dennis to speak in a moment. But before, if there's any question or doubt with regards to restaurant, what we are, I plead and I beg before you vote on page 2 of the narrative that was submitted to the Zoning Board of Appeals. It goes into exactly what Meg just asked about why CHOP is not a why it's not a quote carry out restaurant. And specifically, one of the provisions is that our dining room is a core part of our business, not as per the village code, provided that area devoted to customer seating is clearly accessory to the main businesses. We plan on having 900 square feet of front house dining space inside the restaurant and are also constructing a seasonal outdoor patio for additional dine-in service. If you recall, we did a 180 from when we first started December 2020. In a sense of they are now changing the model from the other 63 other establishments they have to be a restaurant so that we would fit within the definition of the village code. Now, it's my understanding that when it was referred to the Zoning Board of Appeals, the building department found that it was going to be a restaurant. That was the way it was defined as such. And I would certainly, again, implore you to review that if there's any questions in terms of whether or not we're a restaurant or not. Dennis, if you want, I know you were trying to say something.
Sure. No, I mean, we largely agree with Chairwoman Kramer and our attorney, Andrew. We really have nothing further to add on that point. I know that Nick Marsh, our CEO, joined late. If the village planner, if you're able to elevate him. But we really have no further comment on that. We agree with every comment made.
And before you do close, if you so choose, obviously we're going to ask that the public hearing component be closed this evening. I know that Joseph would also like to be heard as the landlord for the property.
Hi, everybody. My name is Joseph Duche. My company is Janelle Real Estate. Thank you for having me on the call. I know I wasn't on, some of the other calls. I'm the lead owner of the building. My family, we own about, 95 properties across the country. Our main goal is to buy property to improve property. We've heavily invested in the community of Mamaroneck. We purchased another property on Boston Post Road, just to give you a sense, where we actually put City MD was the tenant that we installed at the property. There was a proposed Orange Theory Fitness that was supposed to go into that property that was, that had trouble getting approval with ZBA for whatever the reason was. And we purchased the building, thank God we had the opportunity to put City MD in because it was a very, very good tenant to have in the community during COVID-19. Furthermore, we purchased this property, and our intent, our goal was to find a use that was going to benefit the community, that was going to really, change the landscape of the block, cater to the high school across the street. We're investing, probably over $1 million in tenant improvement costs between the landlord and the tenant. That's going to go into this property, add tax dollars to the city. And I think it's really critical that a vote happens tonight because in the lease, we have a clear termination right. And unfortunately, obviously we've been, I know through this process now over 9 months, and we're at the same place we've been 9 months ago where we don't have an approval yet. But the deal is really on edge, and it's not going to happen unless we get an approval tonight. And the problem is that we have to start building out the space. The money can't just sit doing nothing. We really want to spend money building out the space and getting it, improved. So we're really just asking tonight if you can work with us and, try to make this happen. We're willing to kind of do whatever it takes to get an approval, so we could start the work. And just to say something even further, the tenant's been through a lot the last 9 months. The landlord's been through a lot the last 9 months. We're both here together trying to make it work. So if we have to change something, if there's a little bit of tweaking here, tweaking there, whatever we have to do, if there's 1 extra parking space, 2 extra parking spaces, we just ask that, whatever's decided on, gets decided on tonight before this deal goes sideways. The other 2 or 3 tenants. Oh, sorry, David. Go ahead.
No, please.
Oh, I thought you wanted to
I'm
stop.
just trying to share, just telling him I want to ask a question, that's all.
Listen, we respect everybody's decision. We're open for any questions, accommodations. We really want to be here. We really want to build this for the community. We think it's a healthy alternative. The other users that came to me before this, just so you get a sense, they were Wendy's, Taco Bell. I mean, it was worse than the McDonald's that's on the same street. We don't want that. We want a high-class, beautiful restaurant at the property with dining. We want to cater to all of you on the call. We want it to be a good part of the community. So with that said, that's really all I wanted to add, being that, I'm putting up a lot of money to make this happen. And, obviously Nick and his team are also investing a lot of money to make it happen. We just really want to get started, and we don't want the deal to go sideways. So just that's all I had to say. Turn it back to anybody else.
Did someone say they had a question?
Yeah, I have a
Anybody
question.
has a question for me,
Yeah.
obviously
I just have a very quick question. I just want to make sure I didn't misunderstand you. I thought what you said was if it's not approved tonight, then you have a right to terminate and it will go sideways and you will terminate. Is that what I just want to be clear on that.
I'm saying
you're
that
saying
the deal that to answer your question a little bit more.
No, I just need
a
an
little bit more
answer on that.
clarity.
No, but I understand you have the right. All I want to know is, I just want to know if what you said is what I heard, and that is what I heard is what you said, and that is, are you saying that if it's not approved tonight, you're inclined to cancel it?
So I'm gonna reiterate what I said. Nick Marsh has the right. So I am the landlord, right? And I lease the property to Chopped. Chopped has the right. If they don't get an approval within a certain period of time, they could cancel the lease.
Oh, I see. Okay.
I'm on the call because they've been through, I think, 5 or 6 meetings. They've gone through multiple people, I guess, on the board that has changed over throughout the process. I think there was a person on the board that's not on the board. I don't know all the fine details, but they've been through a lot. They really want to be at the property. But yeah, they could cancel. In the meantime, I'm paying all the carry costs on the property, real estate taxes,
Okay.
insurance. It's not your business, but
No, I understand.
I
just misunderstood you.
want the
just wanted to clarify.
landscaping. I want the landscaping to be green. I want it to be healthy. I want the property to look beautiful. I want the roof to not be leaking. I want it to be a property when you all drive down Boston Post Road, you're proud of the property. I'm not an investor that wants to come into Mamaroneck to build an average product. That's not what I do. That's not my business. I invest in A+ properties, and I invested in Chopped because they're an A+ tenant. And with that said, they do have a right to cancel the lease. If they cancel the lease, again, the tenants that I was talking to, aside for Chopped, were Taco Bell, were Wendy's. There hasn't been a lot of tenant interest in general, due to the pandemic. So I just, with all of the facts,
Gotcha.
I just want everybody on the board to know, what we're up against. And I really do feel that this is a great use for the property, one that you don't find every day. You don't find a quality restaurant operator like Chopped to come into your building to spend millions of dollars to improve the site. That's just, you know,
Thank
just for
you.
clarity. I hope that
Yes, thank you.
helps, David.
Yeah, no, thank you. It explained it.
And I truly, one more thing, I truly mean everything I say. So everything about improvement is what I do in life. I was taught by my uncle. You know, he's retired, semi-retired on the golf course. So he relies on me. If he looks at a building and he doesn't see it in mint condition, I'm in very big trouble. And so I really live up to the standards. I live up to an A+ standard. I'm a perfectionist in what I do. And I picked Nick and Dennis because they're absolute perfectionists. I think their build out is a stellar build out. It's really second to none. And I think you're gonna all experience it when you allow us to build it. I really do. I think you're gonna love it. I think you're gonna absolutely love it. And the quality of the food is also amazing. So
Thank you.
Thank you, Joseph.
thank you. Thank you, everybody.
Does anyone else on the applicant want to answer, have anything to say about Meg's particular question or the issue about restaurant, type of restaurant? Meg, do you have more questions?
That was it.
Anyone else on the board have any questions?
A motion?
Oh, well, let's just make sure, Greta, sorry, I can't,
Public also.
I'm sorry.
I didn't hear what you said, Greta.
I said, no, I'm ready to close.
Okay, so someone want to move to
Can I
close?
ask the public, is there anyone from the public wants to speak? Did we have anybody in the public?
It's a good, thank you. It's.
I don't see any hands.
Okay. Somebody want to make a motion to close?
Make a motion.
Second?
Okay, Meg,
Yes.
Greta,
Yep.
David.
Yes.
And I vote yes as well. So the public hearing is closed on this. We may discuss it tonight. It is conceivable we would vote. I don't know that we will, but the hearing is closed. Thank you.
Thank you very much for your time this evening. Ms. Elmer, I have one other matter. I believe that's item number 2, so I can hang in here, or you can let me come back in however you.
You are here for 308 Mamaroneck Avenue?
Yes.
Thank you.
Okay, thank you. All
Thank
right,
you.
you can stay, Andrew, you can stay. You don't have to leave and then come back. I have to wait till I call it, but then, okay.
So
So
we're gonna drop
everyone-
off. Thank
So
you,
everyone
guys.
needs to drop off.
Thank you. Have a good evening.
Okay. The next item on the agenda is case number 11 SP 2020 308 Mamaroneck Avenue, which is an application for a special permit, and it's an amendment of the special permit. Is the applicant here? Or I guess, Andrew, you're the applicant, you said.
I am
Yeah.
counsel for the applicant. If I could ask Ms. Elmer to please elevate Mike Arici, Arici.
Let's see. I don't see him present. Oh, okay, here we are.
Mike, if you could raise your hand. Makabuku. Is that him?
I think this is him.
Mike,
Yes,
could you
raised.
go off, could you take your mute off, Mike? And there you go. Fantastic. Okay, wonderful. All right, good evening. Again, Andrew Spatz, 650 Halsted Avenue, Suite 105, Mamaroneck, New York, 10543, on behalf of the applicant at 308 Mamaroneck Avenue. Just two things. One, this matter, we are resolved with the matter that was previously pending in Village Court. I just want to state for the record that the judge presiding was Judge Gallagher. I have no objection to this matter being held further with the participation of Ms. Heaney at all. I feel that this can be held in a fair manner. And I am confident that there's been no dialogue exchange with regards to what transpired either in court or bench conferences that were held at the bench. So I'm comfortable with this matter going forward with Ms. Heaney.
I would just confirm that I've had no conversations with my husband about this matter. And in fact, the first time I heard that he was involved in the matter is when you mentioned it
Yes, and
last
I
meeting.
appreciate that. We made this disclosure in court, and I'm just trying to make full circle so everyone is on the same page. So thank you. So if I may, we are requesting new hours of operation from 11 a.m. to 12 a.m. That would be midnight, Monday through Thursday, Friday and Saturday, 11 a.m. to 2 a.m., and Sunday, 11 a.m. through 10 p.m. Later hours would not be unique to this property, as Cafe Mozart once operated as a restaurant cafe for many years at this location. And the special permit granted back on November 5th, 2020, unfortunately restricts the applicant from operating his business as intended, which is similar in nature to that other form of business that was their Cafe Mozart. There are two major circumstances that I think we need to talk about this evening. And I'm going to ask, there's 2 points. Let me finish my point, and then I certainly welcome comments or anything from the Zoning Board of Appeals, because what I'm going to share, I believe, is going to set a different standard here in the village of Mamaroneck, especially as it relates to restaurants. And it's something that I think we've taken for granted and something that we have not really explored and had a dialogue about. So just bear with me, and at least for point one. The courts have held that municipalities are not permitted to use their zoning powers to regulate the internal operations or details of a business. In fact, unless there's substantial evidence or a nexus established showing how the hours of an entity would negatively impact the surrounding neighborhood as part of the special use permit, New York State courts have struck down conditions imposed by zoning boards that restrict the hours of operation of a business as an attempt to regulate its internal operations. This is, as you know, the central business district with limited residential use in the immediate proximity of the property, this specific property. At this time, we're not aware of one single complaint by neighbors related to the hours of operation. Simply put, there is no evidence or nexus that the intended hours would adversely affect the neighborhood. In the matter of Westbury Trumbo Inc. versus Board of Trustees in the Village of Westbury, the court concluded that the generalized concerns which were uncorroborated by empirical data are not probative and any such potential detriment. In fact, in the matter of Slaughter and McAllis, the court invalidated hours of operation set forth by ZBA as it concluded, quote, the Board of Appeals has no power to impose conditions which apply to the details of the operation of a business and not the zoning use of the premises. The incident application is a permissible use in the C2 business district. As pointed out in the matter of Old Country Burgers versus Town Board of Town of Oyster Bay, quote, the power of a zoning board to impose conditions and granting a special permit is not unlimited. The conditions so established must relate directly to the proposed use of the real property and not the manner of operation of the particular enterprise conducted on the premises. It's important to note that with the exception of showing that there is an adverse impact on the neighborhood, the only manner to impose hours of operation would be through a legislative act. That means that our Village Board of Trustees, when they establish the various zones in the village, could certainly establish a cap of hours, however it pleases. It did not do so. Therefore, the ZBA would be restricted to the discretion set forth by the courts in regulating the internal operation of a business. Let's talk about the hours of operation. The village code provides absolutely no definition for the hours of operation. Unlike hours of construction, parking, etc., our code does not state the required or minimum hours of operation in this zone. This means that an individual may certainly enter an establishment and place an order before the hours of operation concludes, but this does not mean that the establishment has to be cleared out or empty at that point. Moreover, it can be inferred that at the conclusion of operation, no additional tables could be seated and the kitchen may no longer prepare orders, but there's absolutely nothing in the code which states that occupants must vacate the premises at the conclusion of operation, as this is common practice in the dining industry. And this is something that should obviously be taken up by the Board of Trustees, obviously not today because we're dealing with other situations, but in the future. What is clear is having expanded hours will afford the applicant the opportunity to run a successful business, especially in light of the return of our new norm. It should be noted that this particular property is not located directly in proximity to residential units, specifically the Regatta or the Sweetwater. It is somewhat insulated by other commercial, retail, and culinary-driven businesses in its immediate proximity of Sal's, Smokehouse, and a bank. And by virtue of the location, the expanded hours would not create an undesirable change in character of the neighborhood, would not jeopardize the public health, welfare, and safety of the community, and it would not have an adverse effect or impact on the physical environmental conditions of the neighborhood. So I leave you with several concerns that we have with regards to hours in itself, but also in terms of the definition of operation versus closure.
Let me first say that I don't want to get into it. You know how you know, and you are fully aware, this board has, and I expect will continue where it is concerned about possible noise to impose hourly restrictions. That's all I'm saying. I'm not going to discuss the legalities of it right now. But my question for you is, this restaurant and this particular restaurant has been issued numerous violations for failing to close at the hours that it has. So in other words, it is not complying with the hours that have been imposed on it already. On what basis are we to assume that the expanded hours will be in fact complied with and that the owner will not continue to operate it the way the owner, that's the first question I have, that the owner will not continue to operate it when the owner wants to, regardless of what the special permit says?
That's actually not a factual, that's not actually accurate, Chair, and I respectfully disagree with.
We had a new violation this the last week or two. There was a violation for being open after hours.
Chair, what I'm, if I may, the previous violations that you make reference to, well, let's take a step back. Are we talking about why the Zoning Board of Appeals should trust my client with expanded hours, or why are we hearing this evening? I just want to make sure I understand what we're asking.
No, I am asking you, you want us to extend the hours. Yes. And my first question is, when you extend hours, when the board issues a resolution and sets conditions, the conditions are premised on the principle that the recipient of the special permit will in fact conduct its business in accordance with the resolution. Now, with respect to the hours that were imposed in the prior resolution, the owner has not in fact conducted its business in accordance with those hours based on the violations that have been issued. So my question for you is, now you're saying, okay, we're going to make it later, but on what basis are we to assume that with the later hours, the owner will in fact comply with those restrictions?
Because we have not been, that's a very good, thank you, Chair Kramer, for asking that. There is no proof, or I should say, there is no historical context where we haven't. And now let me explain to you why. Let me explain to you why. Let me explain to you why.
Explain to me why.
Well, first of all, the violations that were issued were based on the wrong resolution. The hours were not correct. That's number one. Number two.
Excuse me, in what way were the hours not correct?
Because it made reference to the wrong resolution, Chair. The hours made reference to in the village complaints were making reference to the resolution passed prior to my clients.
The resolution, you've said that the resolution passed before, and the resolution that you submitted showed that the hours for Cafe Mozart were longer than the hours for your client. Therefore, if your client violated the longer hours, it as a matter of whatever, as a fact, violated the hours that were in this resolution. Just because the police or whoever recited the wrong resolution in the violation may mean that the violation was not correct, but it doesn't mean that your client did not violate the hours.
There was a different tenant in there, but before
If I may,
this one and Cafe Mozart, right? Yeah.
if I may, I'm making reference to Sweet Symphony LLC for Moonlight on the Avenue, which was passed on May 3rd, 2018. The hours that were quoted and made reference to in the violations were made reference to in this resolution. We have different hours.
And
Our
what were the hours in that resolution?
The hours in this resolution were specifically Monday through Thursday, 10:30 to 10 p.m., Friday, 10:30 to 11:30, Saturday, 9 a.m. to 11:30.
And that is the hours that your client was limited to.
No, we weren't.
I'm looking,
Chair, I'm looking at November 5th. We were permitted to operate
till 10 p.m. Monday through Thursday, to on Friday to 11:30, on Saturday to 11:30.
the date with which the violations were issued, we were permitted to be open until 11:30. Some of these violations were issued at 10 o'clock, 10:30. Some of them, there was a 1 minute difference. And if I may, there were 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. There were 11 time violations. Only two had weight. That's it. Okay, only two. The rest were gone. The rest were dismissed.
And were they dismissed because the village patrolman, as you seem to be indicating, cited the wrong resolution, or because in fact they were open when they were permitted to be open?
Well, one of them was because it had to do with property being placed in front of a bank.
I'm not asking you about anything other than hours.
Yeah, one of them had to do with an hour. And even that, quite frankly, Chair, to my chagrin, because operation does not mean closed. Operation is not defined in our code. The operation has absolutely, there's nothing in the resolution that stated that the premises had to be vacated at a certain time. You could walk into a restaurant at 10:29, place an order, the kitchen is closed thereafter. That does not mean that everybody has to vacate the premises. It means that if somebody walks in at 10:31, they cannot be seated and they cannot order. All of us sitting on this call this evening, on the Zoom call, have been in a restaurant at one point or another where someone will come over and say, if you want anything else, please let us know, the kitchen's going to be closing. Or if you try to walk in, we cannot seat you. So I beg to differ in terms of operation versus closure. And I don't blame you, Chair. I don't blame the zoning board. It's our code. Our code does not specify what hours of operation means. And my clients certainly shouldn't be prejudiced by that.
I'm not sure why that's relevant. There's nobody's assuming blame. There is no blame at here. There's the only blame that would be here is if someone doesn't follow the resolution. So you didn't really answer my question, but let's move on from that. Does anyone else on the board have questions for the applicant?
So the hours that you're requesting, you feel that this is sufficient. So you've considered your business model and how many hours you need. And so you feel that you will not run into, that this is going to work for you now. Because I do think that you're doing the right thing, that you got some violations or there's some confusion about what hours. And so thank you very much for coming to the ZBA and trying to straighten it out and request it. I think that's the right way the right course of action. I also hear that you went to court to clear up some things. I think you also got your sidewalk cafe permit back. So it seems you're working through some things. So I think I'm also considering, the things that you just said, Mr. Spatz, about exactly when does operations end, or could it be just people cleaning up? Could it just even be your own staff that's just hanging out after work? We don't know. And so I would like to ask, though, from a zoning point of view, if we did extend the hours to what you asked, would you have any problem if we asked at a certain time of night that your doors and windows closed?
Absolutely not.
You're gonna-
I have no problem.
So you're going to start at 2:30, but at midnight, you got to keep them windows and doors closed just to make sure it's a peaceful atmosphere for everybody else.
We've been, and I've had the good fortune of representing other establishments in the community, as you know, and absolutely, my client understands at 12 o'clock, do they have to have music? Absolutely not. Again, we are in the village of Mamaroneck, we are suburbia, but we're also in the commercial district. We understand that. But if that was a requisite so that my client could operate, remember, it's getting colder too, so we're going to be indoors more. People are vaccinated, the dynamics are going to be different, Ms. Jurgen, but absolutely, I've spoken with my client about that, and whatever requisites would be necessary, we would follow. And I want to point out, that's the good news. That's the silver lining here, is the violations that we've been making reference to haven't come from complaints about noise or anything else. Mere observations, yes, by either whether it's a village code officer or police, yes, but and that's also a very good point, is fortunately, we were very successful in court because we had documentation and photographs and of the interior reflecting that the individuals that were in there were actually employees. They weren't even guests. So fortunately, my client had the wherewithal to preserve this, and we were able to establish that. But the bigger question, I agree, is what is hours of operation? Even if you said to us, we want everyone out by X, Y, okay, we got it, clear. You shouldn't have anyone seated. The kitchen should be closed at, let's just say, midnight. That we get that. That way we know at 11:15, we need to tell people, if you want dessert, you need to tell us now because the kitchen's closed at midnight. If you want us out at 1 o'clock or 12:30, we understand that. He being the applicant, will have everyone out. So I wanted to preface, and Chair, getting back to what I wanted to preface, it's not a blame game, it's not at all. It just so happens through the judicial course and through the application and the exercise of going through the zoning board, I did my due diligence. I did some research on this, and it is confusing. It is confusing of what is operation, what is hours of closure, especially as it relates to having bodies in the premises, and also in terms of the ability, if you're not interfering, if you're not creating an adverse impact to the neighbors, where in the future do we draw the line in terms of hours of operation? I definitely agree with you. I live here too. I don't want something that's going to disturb my peace and quiet enjoyment of the village of Mamaroneck. So I completely agree with you.
I have a question. I have a couple questions.
Sure.
When you have these hours that you're seeking, how are you defining hours of operation? At the time, will the kitchen be closed? Will the establishment be closed? How are you defining it? Because you're saying it's ambiguous.
Because the rule of thumb that my client was doing was the kitchen was closed. For example, at 10 o'clock, I'm just using at 10 o'clock, kitchen is closed. I roll in there at 10:01. Sorry, you can't be seated, and B, you're not ordering. At 9:55, if you're gonna come in, you have 5 minutes to put an order in because the kitchen's closing at 10 o'clock. So I believe, and correct me, Mike, if I'm wrong, that was the rule of thumb that you were applying, that the hours of operation, the kitchen was open between A and B. At B, anytime after that, you were not serving alcohol. B, you were not preparing food.
So in other words, you maintain that the place could be open, but just as long as they weren't serving.
Mr. Newfield, I mean that if, for example, if you come in at 9:30 and you've already ordered and you're sitting there, yes, open in the sense of you're still dining, but could you order anything else? No, the kitchen is closed.
When does the actual operation stop then? When do they close the door if somebody wants to spend the evening sitting there?
Mike, I'm gonna throw that to you because I'm not, how do you determine when it's time to leave.
Good evening, everybody. So is this going based off the previous hours or moving forward?
I think Mr. Newfield's just asking you a very simple question. Can you explain? Okay, let's assume the time is 10 o'clock. That's the time you're supposed to close.
Okay.
At what point, I order dinner at 9:30. At what point do you say to your guests, patrons, okay, you gotta leave?
9:30. On a weekday when I'm supposed to be closed at 10 o'clock, my kitchen closes around 9:20, 9:30.
And what time do you, what time do people get asked to leave, or do you tell them we're closing now?
So that's the problem we were having. So the resolution says you have to have everybody out of there by 10 o'clock, for instance. But we stopped taking orders after.
Mike, if I can, Mike, I think Mr. Phil's just asking, at what point do you tell your patrons it's time to go?
9:30.
We hear what you're saying before, but I'm curious to know what time, at what point they're enjoying their evening, they finish the dessert, no more drinks. At what point are you able to say it's time to go?
10 o'clock. I didn't understand the question well.
Okay, Mike,
No,
Mr. Newfield, maybe you can expand. Maybe I'm not asking it right, but I know what you're saying, David. Mike, if the restaurant closes at 10, the kitchen
Okay.
closes at 10, I walk in at 9:30, I order, I'm sitting there with my friends. At what point, after the kitchen's closed, the bar is no longer serving, how long do you wait before you tell somebody, okay, you need to leave because the kitchen's now closed, we can't serve you any more drinks? An hour, 2 hours? Can I sit there for 4 hours? At what point do you draw the line saying the kitchen's closed, bar's closed, you need to leave?
That's what I'm saying. If people walk in there at 9:30, I tell them my kitchen is closing. You got to order. And then I try to get them around 10:15, because that's what I was supposed to be closed by.
I would note that on prior resolutions, and I just went through a couple of the resolutions, we have specifically said that the hours of operation shall be X to Y, and that food shall not be served and customers shall not be permitted within the premises outside of the hours of operation. So the hours of operation established customer hours, did not limit when. I know there were some cases where we specifically limited, I believe, for Molly Spillane, we actually limited, but not everything. Most of the restaurants, we just said when you couldn't have customers. So you could stay cleaning past the closing time, but you couldn't have customers in there.
Chair, in all fairness, I know, because I believe I represented a couple of people that lived in proximity to Molly's. Yes, that was a very unique situation where you had an outdoor.
Right, yes. So
But-
here,
Yeah.
as Cafe Mozart, I'm looking at the Cafe Mozart resolution, and it said, and food shall not be served and customers shall not be permitted within the premises outside of the hours of operation. So the hours of operation are X to Y, and when it's Y, all the customers have to leave, but the cleanup can take place and your employees can stay there and wash the floors and do whatever else they do to clean up. There was no restriction in general on that. So I think
If we've asked him to close the windows and doors and customers linger, what does it matter to, in a zoning sense, what does it matter how much longer that they linger? Like maybe not allow any more new people to come in, so you're not increasing a party, you're not creating some sort of situation. But as I hear this, it was helpful, Mr. Spatz, to say, we've all had that in, where we went late, we scrambled, we got some dinner and we're sitting in a restaurant. And it's hard, I know, as a business owner, to say, oh, you got to get up and leave now. I'm probably not going to have a really good feeling about this restaurant that I got pushed out. So I'm starting to be aware of, are we getting a little intrusive? And I'm trying to weigh that next to what would be the impact zoning-wise on the rest of the community, especially if we've asked that the windows and doors be closed. Don't think it really matters that people, how long they stay.
what we've noticed on other applications.
I'm sorry,
answer your question.
I'm sorry, let me just finish. As long as allowing more people to come in even though you say, oh, we can't order, yeah, but I just want to come in and visit. Well, you'd be creating a different kind of gathering space. But you're talking about the people who were customers who bought something and they're lingering past the time that they could order something.
Absolutely, Ms. Jurgen.
What we have said in the past and what members of this board have specifically been concerned about and have pointed out, actually, I never did, other members of the board did in fact say that, is yes, but people are making noise, notwithstanding that the windows are supposed to be closed and the doors are supposed to be closed. Lots of noise comes out when you open the doors and people come in and go out. So you're not letting new customers in as people leave. Somebody leaves just at closing time, other people are still there. They're still making noise. If they're having a good time, they're still making noise. So if we're going to establish hours that we want, then I think that if we're going to, and that's up to, we'll have to figure that out, then I think we need to leave the way we have done it on several, which is at the hours of operation, whatever we agree to is the hours at which customers have to be gone. And generally, if you want customers out of there at 1 o'clock, you don't close the kitchen at 1:45. You
Right.
close the kitchen sufficiently in advance. And that is what is done in a lot of restaurants. They close the kitchen sufficiently in advance. Yes, the restaurant, you could be there till 1 o'clock, but kitchen is closing at 11:30. Kitchen is closing at 11:30 and I don't know what the right hour is. Then presumably people are not sitting there for 2 hours when they finish their food and finish their drink. It's
I
not.
agree. Chair.
Yeah, I just wanted to just say, I completely agree with what the chair said, because the cases that uphold the right to have hours, and there are cases that completely always say this, are based upon the operations adverse effects upon the neighborhood and others. Well, it really doesn't matter to somebody who's the recipient of the noise or the problem that the person has already ordered or hasn't ordered. And I think it's a cutoff date for operations. It's always been that way. And I think that they should just tell people, listen, the kitchen closes at 9:30 and the restaurant closes at 10:30 and whatever hours it is. And people say, fine, they understand that. Otherwise, you're just creating the problem. But you can't just say, well, stay open as long as you want to hang out here. That's the problem. People can hang out and they could be, whatever. So.
Mr. Newfield, I agree with you, and I agree with Chair and.
Well, I thought you earlier said that we couldn't control the hours when I heard you say that, and I don't see the cases. Since you said that, and I'm finding case after case in the second department that actually says limited operations is confirmed. The condition is proper because it relates directly to the use of the property and is intended to protect the neighboring residential properties from possible adverse effects to the petitioner's operations, such as anticipated increase in traffic, congestion, parking, noise, etc. So I didn't follow you when you said we couldn't do that, because I think we absolutely can.
Mr. Newfield, I'm not saying you can't, but there has to be a direct nexus to the traffic and adverse impact. It can't be speculative. There has to be a direct nexus. I'm not disagreeing with what you just said, absolutely. And I will be more than happy. Again, this is more academic. I'll be more than happy to forward my case law to your attorney for ZBA so it can be reviewed. It's very clear and precise.
Well, it can't be speculative, but I'm not sure you have to have proof who it will affect and what day it will affect them and how. So be it. Send the cases, send them to the board, please. Okay. Thank you.
No problem.
Okay. But
I have two other questions for the applicant. You said that you wanted to be the same hours as Cafe Mozart, but Cafe Mozart closed at 1 on Friday and Saturday, and you want to close at 2 on Friday and Saturday, so that doesn't sound the same. And the second thing is, you just referred to the Moonlight on the, whatever that Moonlight restaurant was closed, but I did not see the Moonlight on the Avenue resolution in the package. So if you could please send the Moonlight on the Avenue resolution to the board, because I don't believe it's in the package.
I believe it's on your.
And if I missed it, please let me know where it is, because I don't see it.
It's been downloaded on the Mamaroneck Village material.
That's what I'm looking at now, and I just don't see it.
That's
So
okay, Chair. I'll be happy to scan it, because I'm sending Charlie right now.
Sometimes it's within an application. It's within the whole application.
yeah, no, I went through. There's lots of resolutions, and there's duplicates of a lot of resolutions.
Yeah, okay.
But they all seem to be the Cafe Mozart.
That's where I found it, but I'll make a copy. I'll send it to you.
Thank you.
No problem.
So but now the first question about the 2 a.m. versus 1 a.m.
I'm sorry,
I
I'm sorry, I'm trying to multitask. The 1 a.m., 2 a.m. So it wouldn't be identical to the Cafe Mozart. My client has asked that he maintain hours to 2 a.m., but let me assure you, and I'm pretty, Mike, correct me if I'm wrong, if you were able to get similar hours to that, you would be pretty happy. Am I correct?
Correct.
Exactly.
But yeah.
I understand. We understand. We ideally too, but listen, this is a dialogue. We're having a dialogue. We're doing our application, and it's important to be receptive to.
I'm sorry to interrupt. I just want to point out something. So I only have music playing Fridays and Saturday nights, and I don't have open windows. And those nights I will be closing the door at 10 o'clock. So I was closing the doors at 10 o'clock, an hour and a half before closing. Just want to point that out.
I just have one question, and I know the answer to this, but I think it'd be great to have it clarified on the record. You do have a valid special use permit at the moment, and you're not seeking a renewal. This is an amendment of the valid special use permit.
Yes, Council, that is absolutely correct. Our resolution was given and granted November 5th, 2020. My client came to me specifically as a result of some of the issues and misunderstandings in the past, seeking the additional hours of operation.
Thank you.
Thank you.
I have a question about the parcel history. It looks like there's one open item for a sign without a permit issued 2/17/21.
I don't know anything about that.
Well,
Is that exterior? Mike, did you go to the BAR?
I don't think that's for this
Board of
location.
Architecture Review?
That's not this location.
it says, hold on.
That's for 419 Mamaroneck Ave.
It says 308 Mamaroneck Avenue.
No, we have the sign approved.
Well, I'm just reading, it was in the packet, and it says address 308 Mamaroneck Avenue. Unit 31. Issue date 2/17.
I'm sorry, I'm not aware of that.
I don't know what to say. It was in our packet.
What's the date of the violation, since you have it in front of you, Greta?
It was 2/17/21.
We have no one from the building department here I know we have a nice planner here, but we don't have anybody from the building department to give us any information about them. Do we?
Is there anybody online? No, not tonight?
Not tonight. I don't know. I don't know. I think the changing of the date led to the not being able to get one here.
Okay.
I don't know why.
Well,
I think we
certainly,
need to follow up whether or not that's the correct address or what that exactly is.
and listen, if you were inclined so much as to proceed with this, obviously, if there are any issues with the signage, we could be conditioned on my client promptly, Mike, I know this, addressing those issues. So we're not gonna, we don't want this to derail the application itself, but obviously, if there's anything that needs to be addressed, we will address that.
It looks like I found what Greta's talking about, and it looks like it says complaint was closed on 5/19/2021.
Where does it say that?
So I see where you're saying sign no permit, then directly underneath that, it says 5/19/2021 complaint closed, although it's a different complaint.
Yeah, sidewalk cafe condition violation. I think that's different.
That wasn't, we didn't resolve that until
And it's two different complaint numbers.
Yeah.
the cafe, no, the property, that wasn't resolved until August. So no, that would not have been closed out until, I'm sorry, I stand corrected. That was July, Ms. Haney. That was when he was able to get back his application. sidewalk permit.
Yeah, that's not my question. The question is the sign, no permit for a sign. That's still open. Complaint number 210513.
All right, so I guess because you have to check into that, so I think that's just something you'll have to do, Andrew, and check into that, find out if it is, in fact, if that violation was issued, whether it was closed out, what the problem was, and confirm whether or not, and cure it if it is correct. And let me rephrase that, cure it regardless of which property it was on.
Understood.
Anyone else on the board have any questions? Is there anybody from the public who wishes to address this application?
I don't see any raised hands.
Okay. Do we want to, what does anyone want to do? We're getting a couple of things. We're getting a copy of, unless someone can find the Moonlight on the Avenue resolution, we've got
Sure,
to
I
get.
could, if you want, I could send it right now. I have it in my hand right here. I can send it to council and you can have it for this evening. I would respectfully ask that the public hearing be closed and proceed with convenience. Yeah.
Understood. But I just want to know if there's anything, so we need to get the sign violation, the question resolved. So I guess we certainly want to have an answer to that.
Would that, though, Chair, would that delay the closure of this matter and being able to render?
No, we could leave it open to get any, a proof that you have in fact complied with, that you have removed the violation or that the violation was improperly issued. That's not a big deal. We can close the hearing and leave it if we want to. If the board members want to confirm that it's closed, we can do that. Or if we decide to vote tonight, we can make it contingent on whatever we do. So that's not going to keep it, that's not going to delay us from closing it. I just want to know if there's anything else that any of the board members are looking for before we do it. That's all. So was that it? Was there anything else that we wanted to get from the applicant? Before we, nope. So then I guess that's it. So then when we close, we can...
I do see one raised hand.
Okay.
There is no name attributed to this individual, but I can allow him or her to speak if you'd like.
Yes, please.
Okay, I'm going to allow this person to talk.
They should identify themselves.
The person with the raised hand who wants to speak, if you would like to speak, yes, please identify yourself and then proceed.
Hi, everyone. This is Assistant Building Inspector Dennis Drogan. I did the call in again, and I just got unmuted, so this is great. Thank you. So can you repeat what the violation was for the sign?
It's just said no permit.
It just says no permit?
Yeah.
Okay, so as far as I know, my tablet's not working, and we're having some difficulty with the laptop. But as far as I know, regarding that site, all permits have been filed. If there's anything that is still open, it's just not closed yet at this point. They have a vertical sign. They have vertical sign on the side, which there was a permit for, and the awnings were also permitted. They did go to BAR. Everything was seen through. So I don't believe they have any outstanding issues with their signage. So if I could just give you that's all I got. As for the other violations that I had, you guys kind of talked through everything. Any other questions you have for me?
Anyone else? So you're here, you're just you're here, just making sure that you're here for the hearing in case we have anything else.
I'm here. Yes. I'm
Okay,
just using
good. So I didn't realize that.
Yeah, sorry about that.
Okay. All right, if there's nothing else that anybody wants to know from the applicant. Does someone want to make a motion to close or what?
I'll make a motion to close.
There's a second.
I second.
Okay, David,
Yes.
Greta.
Yep.
Meg,
Yes.
and I vote yes as well. Okay, this hearing is closed.
Thank you.
Subject to getting a copy of the, that Moonlight on the Avenue resolution, just because I wanted to see it before.
On its way. I'll be sending it to Charles right now.
Can you send it to us as well so we could see it, or?
Yeah, I don't think he can. He's going to send it to Charles and then Charlie will send it to us.
Okay, fine.
And Mr. Newfield, I sent the other material as well by background. So Charles will have everything. And Chair, I'm going to just take a second because I've shared this with the Board of Trustees, Flood Mitigation Advisory Committee. Again, I say this not just as a business owner here in the village of Mamaroneck, but as a resident. I thank you all and the building department for being here tonight because it's not easy. We've been through a lot, but you are certainly the lifeline, part of the lifeline of this community. And it's often that we forget, we take it for granted about what the job and roles that you all have. The fact that we've been through so much, yet you have showed up here as a zoning board of appeals. We thank you. And as a community, we're very fortunate to have people who are dedicated. And to the building department, keep up the great work. We've been through a lot. So, I mean, I'm just saying this, and I'm thinking, as I said, I was in front of the Board of Trustees and other committees. It really does take a community. So thank you for keeping our village together and the vitality of this village. So that's my words for the night. So be
Thank
safe.
you.
Thank you.
Thank you.
All right, good
Thank
night.
you. Thank you very much. Thank you.
Okay. Okay, moving to the next item on the agenda, case 4A 2021, 539 Jefferson Avenue, which is an application for a variance.
The
Is the applicant here?
Yes, hi, I'm here, Dina Croce.
Okay. Hi, do you just want to introduce and talk about, explain what the application is, please?
Sure, so.
Excuse me, if I could, before you go forward, if I have a question for the chair, am I missing it? I can't locate the building, the actual application online.
I think I saw it. It's hard to remember exactly. Hold on.
Yeah.
Let's look for it.
It goes CO, building determination, surveys. I've seen the survey, the site plan,
It says building ZBA submittal.
building ZBA submittal.
Now I'm looking at the table of contents. I don't have it open in front of me.
Yeah, that's not it, but let me see this.
There it is. It's here. It's about, it's on my, it's page 555.
Oh, building submittal, is that the one?
Yeah, I think that's it for this application.
I just found it. It's X.
Yeah, it's 555.
22.
If you're looking at the PDF pages,
No,
it's page
I'm not. I'm looking
555.
at- It's X2022?
Yep, that's the one.
Ooh, all right. Yeah, you're right. Thank you. There's two of that same number there. One's not it. Okay, gotcha. Thank you.
Are we going to be able to get the hard copies of these applications going
Yeah.
forward?
I had thought that, just moving to that question, Amber had them available in August, prior to the September meeting. If you made it, she had said that if you made arrangements to pick them up from her, she would have them. Now, whoever the next, we have the next, so it would be Ashley, Madeline, I don't know, someone at AKRF, since they are our interim planners unless and until the village hires a new planner. So Madeline, if you would and I will reach out to Ashley tomorrow to tell her, remind her that applications, so every application that has come in for the next meeting should have been, as per our requirements, there should have been hard copies. sufficient numbers of hard copies to distribute to everyone. They're not being distributed anymore. You just have to make arrangements with, I guess, Barbara Ritter at the building department to pick up your hard copy. But I will confirm with Ashley. I don't know what any of the applications are for the next meeting. We have not seen them. I don't know if in fact they've been put together, what's going on. So we have to find out. But I will confirm with Ashley that we do in fact have enough hard copies and that someone in the village can let everybody, the board members, know that they can come and pick them up. Does that?
Thank you. Yes.
Okay. Okay, I'm sorry.
My name is Peter Catazone. I'm from Catazone Engineering. I'm the engineer for the client, and Dina Crochet, who's the homeowner, she's here on the call with us. Yes, we did submit hard copies of the applications per the request. If there's other copies necessary, we're nearby. We're right in the village of Larchmont, so we can drop off any additional copies as necessary. But if you will permit me to share my screen, I'd like to walk you through the project and move forward. I think I'm sharing now. So the address is 539 Jefferson Ave, and we have the adjoining properties. We took the pictures. We have an index of which way we were shooting the photograph. So you can see here to the left of the 539 is 541. This is the subject property, 539 Jefferson Avenue. This view is a wide view of 541 on the left, 539 in the center, 541 on the right. This is between 539 and 535, and another one to the left side. So the application.
Excuse me, before you go, do you have any pictures? I didn't see them, but that doesn't mean they're not there. That were photos of the rear of the property?
I could share some with you.
So that we can see what the conditions are in the rear of the
Yes,
property and the
absolutely.
adjacent property to the rear?
Yes, just give me 1 second to get those up for you. So here are a couple of photographs. This is looking, let me take you to the site plan first, and then I could show you what the pictures are. It might make better sense. So Jefferson Avenue is to the right. There's the dwelling. It kind of almost hugs the left side yard setback. And the two photographs that I'm going to share with you are from the this rear slate patio. One of those is taken straight back to where the pool would be, and the other one is kind of the right side of the rear yard. So again, this is the first shot from the rear slate patio looking straight back. And then here's the other side. So on the right side of the lot, there's a little play area. Left side is the small storage shed. So
is that the shed? Because your survey or your site plan has a shed. Is that on the property?
It is not.
No. Whose shed is that? Is that the railroad that it butts to the back?
So yes, we've contacted MTA, to come visit the site. Actually had proposed to perhaps purchase that portion of their right of way. The MTA railroad is elevation wise much lower than the grade of this backyard. MTA at this point is not interested in selling. There are agreements that could be drafted up as use and occupancy agreements. But you are correct. The shed is not on the property.
Who uses the shed?
The shed is used by my clients. And the white fence,
Okay, was it? So in other words, they're just using the MTA is not using it, so they just put their shed there, basically. Is that right?
correct. So I'll just for ease of,
And this is how we purchased the property 4 years ago. The fence was in existence and the shed was on the property already.
So how do you get to the shed if there's a fence?
No, the fence is,
past it.
the fence is past it. So
I'm
let's go
sorry,
back.
which shed are you talking about? And where's the fence looked like it was
If you
immediately
look on the
abutting?
survey, Robin, there's a reference to a shed.
Yeah,
And you'll see it, but it's after the line because it's after
Right.
the 197. It's after the,
correct. But
Right.
it says vinyl,
The
there,
fence is,
That's the gate that, I'm sorry, you see where it says concrete pad and there's that, to the right of it is that thick line.
This-
That thick bold line is my property line, but the gate is actually where Peter is highlighting.
so what is
the
this
fence.
line where it says iron pin set and vinyl? What is that?
So the vinyl, the iron pin set is a property corner. There is a vinyl fence. Let me just trace it. So where it says vinyl, there's a gate here. Here's the vinyl fence. The vinyl fence continues to this point.
If you
The
go,
iron pin is their actual rear property corner.
so now I'm really confused. Okay, let me take, because this is, so if you look at, go back to your, so kind of move it, let me move it over. It's kind of went to the wrong direction. I don't know if I can on my screen move this. Yes, okay, so if you look at your site plan, your survey, this is your survey, there is a dimension, well, there's no dimension actually of your distance, but so there is something that says iron pin set. Now that iron pin set is your property line, or that iron pin set corner is not your property line?
This is the corner you're talking about?
No, the other corner up to the top.
Oh, okay,
But
yeah.
it's the same corner. It's the same respect.
So same effect. I'm sorry.
Right. Is that,
So those
so is
two
that
are the
line that goes
actual property
between,
corners.
that is not?
Those are the actual property corners.
Okay.
Now, let me just, there's two parcels here, which
Oh,
if
yes.
it's not confusing enough, but there are two parcels. One parcel is
yeah, you've got that on there.
Yeah,
yeah,
it says
it's-
one parcel, but that's not the issue. Here's let me repeat my question. That is parcel one, and then you have parcel two, and parcel two seems to be about 12 feet,
Yes.
right? That's what the
Yes.
survey shows. So we've got your red circles on this. That is the property line. Then, and that says vinyl, so that is your vinyl fence, and what showed that white vinyl fence, I assume, in the photos.
Mhm.
Now, the shed is beyond that.
I'm sorry,
Correct.
there is no vinyl fence though where those property points are. The vinyl fence is, could you show her, Peter?
Yes,
on
let me
where it says
just
vinyl?
trace it. It starts, I'm gonna trace the entire fence. Just let me get rid of this thing first. It's a little hard to draw on. But there's a gate, there's a fence and a gate here. I'm gonna trace the whole property. This is the vinyl fence. It continues to
Right.
here.
Right.
At this point, it turns and stops at the shed. Then after the shed, at some point it picks up again and goes to this side and closes out.
Where?
So then I do not see on your survey a
Yeah.
dimension that equates to that. There is no line that shows that as the property line on this survey. There is no line that indicates the dimension of that property. The normal meets and bounds, the normal.
The shed is not on our property.
It's not on their property, Rob.
The shed, the shed is not on the property. That's
not, so wait, then what is the vinyl fence? The vinyl fence incorporates something that's not on your property?
correct.
Yeah, Robin, there's another survey in the record. I'm trying to think if it's the same one. What's the
Yes.
date of the survey you have up there, sir?
There's two surveys. They're pretty much identical, except that one was updated recently,
Yeah,
and the
there's a
other one
July
is
30, 2021 one I have here.
Yeah, that's what this one says.
Yeah, if you take a look, so I understand, it's a little bit unusual, because you have parcel 1 and 2, and then you have, it's 11.99 feet on one side and 12 on the other. And
Right.
then you have this entire rectangle that seems fenced in. That's an appendage, but not your property. So
not the
property,
property.
basically, it's property that's not used by the owner, it's used by you.
Correct.
Right.
Right? Yeah, I
Basically,
understand.
it's MTA property.
Now, does MTA own the property?
Yes.
Yes.
Okay.
Okay, so now going back to your new site, the site plan that shows the pool.
Correct. The pool is entirely,
So the fence, wait, the fence that is seen in the photographs, that white vinyl
okay, let's
fence
go back to that.
that is seen in the photograph, I'll call this the MTA area. That fence includes the MTA
Yeah.
property?
Correct.
Correct.
Okay, so now my question is, and I've got one about the site plan. So now you go back to your site plan. I'm sorry, I get probably
Sure,
rushing.
no, we'll do whatever you need to see.
So now your property here. Now, are you going to put, there's a requirement, I don't know whether it's, I don't know if it's in the village code, if it's state building code, but there are requirements. If you have a pool that has to be fenced in, are you proposing a new fence for that is your property? Or are you planning on leaving the same vinyl fence that includes the MTA property? What are you going to do about fencing for the pool?
We're proposing to leave the fence as it is, with the exception of the gates at the driveway and at the side yard. Those would have to be self-closing.
So in other words, your fence around the pool is effectively going to be on the MTA's property on the west side, right? Yeah, I got you.
And does that meet code? Because I mean, I don't know what the requirements are for the pool fence. Building inspector?
Well, he's
I
asking
believe
for a
it's-
variance so that he can be doing this. His variance, really, if you own the MTA property, you wouldn't need the
We
variance.
wouldn't need a variance.
Right, but they don't own the MTA property.
I know, so therefore their property ends less than 2 feet beyond the pool.
Yeah,
Correct.
my concern is, my question relates to the fence. Does
Yeah, I know.
putting a fence around the MTA property when it isn't their property comply with the village
Yeah.
code and or with respect to fencing of pools? Pools are dangerous, so I'm just concerned. Building inspector, are you there?
So you want to know whether or not the code requires you to have the fence on the property?
Oh, I just want to
Yeah,
make sure
that's
that
fair
this
enough,
fence
but
is
that-
okay. Yes, that's
Yeah,
exactly
no, that's really what you're saying.
correct.
So, hi, this is Dennis Strogan, the assistant building inspector. So I've been trying to talk the whole time, but apparently I've done mute, my fault. So, so their application, not including the MTA property at all. So that's completely excluded. Where they have their fence and everything, that's a different story. They shouldn't have a fence there. That's MTA's responsibility. The shed that's on MTA's property, that's something MTA has to work out. If they've been using this property for so long, they got to work out that with the MTA. To simplify their application in best terms is that they do not meet the rear setback for the swimming pool
Yeah, we know.
to place.
Yeah, we know that, yeah.
That's not my
Yeah, so
question.
that's it. So don't. So where it says pin on the property line, on the survey where it says iron pin, an iron pin is normally placed for the survey, saying that the surveyor saying that this is the property line. So that's their rear property line. So that's the only thing you need to look at for the swimming pool itself. But for the fence, if they are fencing in the property that goes back to the MTA and around and looping through the whole property, and that's their fence enclosure for the swimming pool, technically MTA can say, we don't want this fence here. It's gone. We haven't used this property for 20, 40 years, but today we've decided that we're taking it back. Now their pool won't meet New York State Building Code because their enclosure would be broken.
Yeah.
So, when you are making a decision on this, let's just put that in writing that, we're okay with, or however you decide, for the pool setback, if you allow it, just make sure that we have in writing that if for some reason the MTA decides to add another track or remove all of that soil and do some work there, that they would have to move their fencing closure to encapsulate the pool.
Yep.
You know, so if they have use of it, that's one thing. But if we don't have that in writing, they're on somebody else's property, and they're encroaching on somebody else's property.
Yeah.
So,
Robin, I'm sorry.
Thank you. That was my question. That's what I was concerned
Robin,
about.
300-2 of the code provides that every private pool has to have the fence.
Right.
It doesn't say, I guess it's an interpretation, I read the rest of it, but it doesn't say that it has to be on their property.
That's fine.
Yeah.
I
And of
think
course, I guess the bigger issue
well,
is,
I wouldn't be giving if somebody put in for a fence permit, which they would, I wouldn't be giving them permission to put a fence on somebody else's property.
but if it's already there.
You know what? Despite that, once you make a decision and however you decide to word it, once it comes to me or possibly Frank, the building inspector, he can use his discretion. But for myself personally, I would not accept it unless I get some type of documentation from Mamaroneck stating that they're allowing a fence to be built on somebody else's property. I mean, let's not call it Mamaroneck, let's call it the neighbor to the right. I decided that I want to put a pool in. I'm going to put a fence on their property as well. It needs to be copacetic with the neighbor next door. They need to have an understanding.
Yeah. What happens if your neighbor has a fence and you go to put a pool in, and my neighbor on the property line has a fence? I don't have to put a second fence directly in front of it, do I?
You do. You
I
do.
have to put a
You
second fence?
need
So
to
there'll be
have
two
your
fences
own
next to
pool
each other?
enclosure that
sorry?
belongs to that property owner. Yeah.
Where does it say that? I appreciate, but that's what
It's in the
Robin
New
was
York
asking.
State Building Code.
So there would be two fences next to each
Yeah,
other.
that's beyond that's beyond you guys. So that's with New York State Building Code. I can't give you the chapter and section, but the pool enclosure must be kept and maintained by the property owner that has that pool. In which, if any point it gets filled in, altered, or changed, then the pool enclosure would be looked at
Well, then,
at that time as well.
well, then I think if that's what the state code says and that's what's binding without a variance, then I'm not sure. Can we see that? Because I'm
That building code,
very confused.
we don't apply building code. That's not for us.
We don't.
Or-
No,
So
I think
going back to
Dennis's
my first statement. Yes, exactly. Yeah,
I
the
think
first
Dennis's
statement was
suggestion makes sense, that it would, or we put something in there that fencing shall comply with all requirements as determined by the building inspector, and leave it completely up to them.
Yeah, but he's saying he wouldn't agree with it. So we
No,
just-
no, he's saying he wouldn't agree with this fence, but we're not determining where the fence is. Dennis is saying that he would want the fence to be put 1.97 feet behind the pool, which is their property line. So that is something that Dennis and the applicant will have to work out, and it'll go where it'll go. So what we wouldn't say that they develop in accordance with the site plan, since the site plan, to the extent we say that, we would have to make clear that, however, the fence shall be as required by the code, as determined by the building inspector, I think is what we'd have to say.
So if I could just,
I don't know why the requirement is there, but okay. All right.
if I could just add to that, the fence is existing. I understand. Thank you for the, Dennis, for the excellent explanation of the fencing requirements. We have contacted MTA. MTA has been to the site. They've met with my clients, and they are aware of the fence. So a couple of things. One is the pool and any sidewalk around it is entirely on the property. So in the event, worst case scenario, that we had to relocate the fence, we could do that without impact to the pool. Of course, they have backyard there that's not theirs, but they're utilizing. It's not utilized by anyone else. We can try to reach out to the MTA again and see if they would, which I think they would entertain a written agreement, a use and occupancy agreement. We could chase that down. Ideally, we would like to leave the fence as it is, but certainly if something, as the example was used, that the MTA now wants to use this right away, putting a fence along our property line does not impact, the pool could stay right where it is.
Yeah, but you don't need to move the fence. What you could do is just put a fence there, a small fence around the required fence around the pool directly, like one that you can see through, etc. And then you have your yard that goes on to where you've been using it, or you can deal with it another way. That's up to you.
Okay.
Madam Chair and Dais, so just to go back to what I said, if you do grant them the variance for the pool and the location in the rear that they don't meet the clearance for, I'm okay with them having the fence in the rear of the property. They can obtain some documentation from Metro North, but one day, if they do decide that Metro North comes down and decides to reclaim all of that property land that people have been using, just, we'll have it in writing that they need to move the fence so there's no debate later. That's it.
Well, they have to
Simple.
install their own fence. It's not really a move.
Exactly. So that PVC fence, I believe, belongs to the homeowner now. Maybe they purchased the house with it there in play. But, either way, we just want to make sure that pool enclosure gets moved. So that would just all be in the wording.
So you would want so basically that would be where you would move they would have to install a fence in the event that MTA wanted them off the property or MTA removed the fence. I mean, they could go out one morning and remove it, right?
Exactly. Yeah, they can. They can.
I mean, unless they're going to assert rights. I don't know.
also-
Maybe they've got rights to it at this point. That's their issue.
Yeah.
There are statutes.
That's all.
Real property action proceeding law. It does have something structures on it. So that does give them some interesting issues. All right. Gotcha. Okay.
All right. Thanks.
I do have one question though, maybe for the applicant. I'm very confused about because I've noticed this lately, the past year. Lately I've seen that the planning board is requiring site plan approval on pools.
Well, we've made an application to
Well, my question is that was never the case in the past. They also wanted to impose a special permit requirement, which we rejected as a board, saying it wasn't required. Do they require site? Has an application been made? Have you been told that an application must be made, or has one been made?
No, it's a little bit of a long history with this project. The applicants actually received a building permit for an above ground pool at approximately this location. When they talk to the pool company, the newer type pools can have, they could be partially buried, they could be fully buried. So, they decided that they would, for not a lot more up cost, that they would do it as an in-ground pool. So that's when we went back to the building department and we filed an application for a pool permit. So the first pool permit is, I'm not sure if they closed it out, if it's still an open permit, but that pool was never constructed. This is a new pool permit with a new application fee, new application. We were never directed to the planning board.
Gotcha. Okay. Yeah, I don't know. I've noticed that lately that I see signs saying it's before the planning board. And I have no idea why they've started to do that, because to my knowledge, they never did in the past.
Dave,
John, do you know that, or?
yeah, I've had some back and forth with my colleague Teresa on this. I don't think it's a mechanism of the pool, but it's a mechanism of how much ground disturbance there is. And there's a threshold of ground disturbance in the code that requires planning board approval. So
Really?
it's not related to the pool itself. It's related to ground disturbance and stormwater management.
When you get a chance, maybe she could just send me the code section on that.
Sure.
Thank you. Okay.
So in addition to the pool, which is the subject of this application, we are also providing some stormwater management to make up for the additional impervious. Of course, when it rains, the pool is self-contained. So if you get 2 inches of water, the water would rise 2 inches in the pool. But, you know, we still treat that as impervious as required by the code and still have to provide stormwater management mitigation for that. And that's
Studies about that, but could you explain exactly what you're doing to remedy the increase in impervious surface? Because
sure.
honestly-
So the backyard is relatively flat, and we are installing 4 subsurface detention units. This is a section of those units. They're a HDPE polyethylene arch, if you may. They're about 30 inches high. There's stone beneath them. There's stone around them, stone on top. And then we'll put topsoil seed on it. So as far as anyone's concerned, it's invisible. What you would see from the surface is just a small drain in the rear yard. So any runoff from the patio, from the pool would run to this drain. And there is an existing pipe that discharges onto the railroad right away, which is a drainage pipe. And we're just tying into that. We've modeled the required stormwater storms, the 110 and 100 year, in accordance with the code and with DEC standards. Although this is under an acre, it doesn't require DEC permit, but all of our post-development flows are below what's coming off the road, the property now, in that direction. So we are reducing, you know, the slightest amount, the stormwater runoff that exits to the rear.
Madam Chair?
We want to ask if there's anybody in the public wants to speak? You're on mute.
Anybody else? Is there anybody else on the board who has any questions? Do any of the board members have questions for the applicant? Okay, is there anybody else in that? We go to the public. Does anybody from the public want to speak on this?
I don't see any hands.
All right, does the applicant have anything else they want to say before, or have you finished?
Unless there's any questions for me that this board has, I would request that the public hearing be closed.
I do have one more question. Again, it's a whole about the property. Sorry, I was very confused. So the train is here, correct?
The train is way, you know, what would help is maybe an aerial.
Yeah. Can you put one on? Because I just had one up.
I think I could get one for you.
If I emailed one to somebody, I missed.
I'll just go to Google Maps. Yeah, I'll just go to Google Maps. I thought we had a requirement that you had to submit an aerial as part of the application.
Well,
But theirs is invisible, that's all.
Yeah, it's well, you could see it here. This is the requirement for the plan view, and I mean, it doesn't, the MTA right away, you could see is right up against their property line, but the train tracks themselves are not really very visible or visible at all.
If you look on the Google map, they're very
Yeah,
good. Not the map, if you go to the aerial.
Yeah.
Yeah, here we go. So here's 539 Jefferson Avenue. And this is kind of the limit of their fence. You could see, I think there's a distance. I'm going to say measured distance, but just for the purpose of drawing a line. But it seems like this might be where the end of the fence is, plus or minus. And you could see it's quite far to the, you know, railroad track. So
I just, yeah, there's no, okay, that's fine.
So let's just go, I don't know, call it this is not that accurate. Maybe this shoves over a little bit. So call it 40 feet plus or minus to the actual travel way of the tracks from where the vinyl fence is now. Then you could also, there's various encroachments, along the MTA right away. So, Madam Chair, I hope I answered your question.
You did. That's fine. Thank you. Yes, you did. If no one else does have any questions, doesn't seem like anyone else, nobody from the public, does someone want to make a motion to close? If that's,
I have just one question, and that is with the storm management system that you described, I think you said that there was a drainage pipe that was going to go through the MTA's property.
It's an existing pipe.
Oh, it's an existing pipe.
It's an existing, and it's a small pipe. It's not, I think it's a 4-inch or 6-inch, which we're just tying into that. But it basically exits the slope just beyond their fence, probably 10 feet beyond their fence. You could see a white pipe protruding from the slope.
Have you been using that pipe?
The pipe is an active drainage pipe that's been there since my client purchased the property.
Active or inactive?
Active.
Okay, so the property owner has been using that pipe?
Yes.
Okay, gotcha.
somebody want to make a motion to close?
So moved.
Is there a second?
I second.
All right, Meg,
Yes.
Greta,
Yep.
David.
Yeah.
I vote yes as well. This public hearing is closed. Thank you.
Thank you.
Thank you very much.
Okay, the next item on the agenda is case 7SP 2015 448 Mamaroneck Avenue for renewal of a special permit.
Okay, I am promoting to panelist Mike Rilea.
You're on mute, Mike?
Let's see.
I don't think he's aware we're here.
He is. You have to unmute yourself, Mike.
Madeline, is it possible for you to unmute him?
No, I can't. I can ask him to unmute.
Wait, can you yell out the window?
There he is. He's unmuted. We can't hear you, Mike.
Hello?
Mike, we can't hear you. I don't know if you can hear us. You can hear us.
Yeah, let's write him a note. We'll hold it up to the screen.
If you'd
I
like to
think he
call
knows.
in,
I
I
think-
can.
I think he's looking, trying to figure out what the problem is.
He's heard us. Usually.
Okay.
Hey, you have any highlighters or something?
Can you just dial in, Mike, on your phone?
You can use the chat function if you'd like.
Yeah, let me go reach out
Or
to
you
him.
could do, you could maybe do sign, I don't know how, but that'd be interesting. Probably should have that available.
Mm.
Can you elevate that phone number, I guess?
It says he's on the phone, 51, he's got his phone
Yeah.
number in the chat. So I'm not sure what the problem is.
Okay. If you use your phone, we can hear you.
He says he's
Okay.
on the phone.
Now I think you have me.
Okay, great.
So this morning, my computer microphone went. So I can use my phone, except my phone doesn't allow me to have this nice background, which I'm required to have on all of these calls. So I apologize for your taking a minute extra of your time, but never ceases to amaze me, no matter how ready I am to do something. Thank you for your time. Just quickly, so we are looking for variance for the 200-foot rule for Smash Burger. It is at 448 Mamaroneck Avenue. We came in, the initial permit came in 2015. They changed ownership in 2018. So there was a special use permit that was issued to the new owner on that premise for same purpose for Smash Burger. And there was a condition within that approval that asked for to come back in 3 years and get another approval within the 3 years. So back in February, I started the conversation with Amber to get the approval, and through lots of different COVID-related odd things and technology things and weather, we are now here tonight trying to get asking permission to have the variance for the 200-foot rule for Smash
I'm sorry.
Burger.
I'm sorry, you use the term variance, but it was an application for a special permit. So,
I'm sorry, special use permit, correct.
Okay, just want to clarify that.
My apologies.
Okay. Go ahead. Do you
So
want to just explain what it is, if anything's changed? And
No, nothing has changed. We're just following up on the requirement that was in the prior resolution in September of 2018 to come back in before you to ask for that. The one thing I would note in transparency is that, we did expire September 6th, 21. However, through conversations with Amber and others, we were assured, and because of the cancellation of September 3rd, that wasn't necessarily an issue at this particular point. However, I did want to note that, and we did start the application process back in February and concluded it a couple of different times, and now we're finally here.
the board has always taken the position, the village has taken the position that as long as you filed your application timely, the fact that we haven't decided it within, before it expires, you still can operate. So
That's
no,
okay. Thank you.
No worries on that account.
Thank you.
Does anybody on the board have any questions, comments?
I do have a question. And this relates to, I think it's fine. I realize that you're ongoing business and you're not changing anything and that we granted the special permit. So this is no indication that we would not continue and grant your request to continue on. But I do have a question because I'm concerned that your special permit, and this is not because of you, but because of the ZBA, grants the special permit for a fast casual restaurant, and we don't have that in our code. I actually think that we should be granting special permits for defined terms in our code, not for things that clients come in, applicants come in and kind of make their own descriptors. So to that end, I would like to ask you, is the majority of your business eat in, or is the majority of your business to be consumed outside the premises? Which is the greater percentage of your business?
I would have to check on that, and I don't know that I have that. I know I don't have that information there. I would just in talking that through, be it a fast food restaurant, there's only so much limited space, and turnover and timeliness is there. So I would imagine that there's a lot of takeout and or nowadays between DoorDash and the other services that provide food. I don't have a number on that, but I guess common sense tells me that we would have some bit of a higher number on that.
Okay, I'm not saying that one way or the other would make any difference in renewing your special permit. I was asking that so that we can have the right categorization of your business.
Right, thank you.
No, does anyone else on the board have any questions? Is there anybody from the public who wishes to speak on this application?
I don't see anyone.
Okay, does someone want to make a motion to close? I'll make a motion to close. I move that we close the
Second.
public hearing on this application so we can,
Move on. Second.
okay, exactly. David,
Yes, yes.
Meg,
Yes.
Greta,
Yes.
and I vote yes as well. All right, the hearing is closed. Whether we'll get to it tonight, I can't answer, but you can still operate, so don't worry.
Thank you very much. I appreciate all of your time and help with the storm stuff. So thank you.
Okay, the next item on the agenda is no case number, 437 Ward Avenue. It's renewal of a special permit. Is the applicant here?
Yes, I'm promoting Alice Jane.
Hi, everybody. I'm Alice.
Good evening. Good evening, everyone. So I'm Alice's friend. I'm here to help her out because her, her English is not not as good to answer any questions or to explain. So we are here to once again, good evening, everyone. Thanks for having this hearing tonight. We are here to request for a renewal of a special permit to run a beauty spa at 437 Ward Avenue.
Has anything changed from your original application, what you want, your conditions or anything else? So you want exactly the same thing, just renewed?
Yeah, nothing has changed, just the renewal because it expires on November 8th of this year.
Anybody on the board have any questions?
Yes, as I understand from the original application, that what you do is you provide massage services. And it said that that was 100% what you do is massage services. And so I would say that the special permit that you were granted, we don't give special permits for beauty spas. It was actually for a massage establishment. So thank you very much for coming to us and you got your special permit. But I think the actual categorization is massage establishment. And there are certain standards that go along with that. And so I believe that now that you're coming back, that now that you're open, you've been open for a few years, we need to check and make sure that you're complying with all the standards for that kind of establishment. And I think that, so we need to ask you some questions about that. For instance, one of them was that you have identified your building from the outside as a commercial establishment. And I don't know that you have a sign outside your door saying spa or beauty salon or tranquil spa or in some way designating the commercial use of your building.
My understanding is they have so they're on the second floor at 437. There's a sign by the window.
I drove by and I saw a little neon sign that said open, but I didn't see any kind of designation of commercial, like a name, like spa or spa or or something.
What section?
Okay, I thought they used to have one. Okay, maybe they have to put that back up then. So there should be a sign on the second. So there will be a sign on the second floor by the window.
Mm-hmm.
So their business goes by Tranquil Spa, so that's what they're gonna have by the window then.
Okay, that's cool. But and Dave, if you're looking for, I think the standards are 342-42.1.
42.1.
Yeah. Okay, so that's where I was reading from. So that would need to be there. Also, thank you very much for providing us with your licenses, the massage licenses for New York State. I also see in the standards that how many employees do you have working at your establishment?
So it's so Alice works. She's the owner and she works there. There's her partner who also has a license, and there's a part-time employee who does the cleaning, and yeah, I guess cleaning and any like washing and things like that.
Okay, so there's nobody else that is providing any kind of massage or
Right.
spa services or something there? Okay. I looked on your website, there was some testimonials and there was a number of names of enjoying your services. So I just thought there might be some more employees because there were some other additional names there, but.
Yeah, that's not my understanding. So yeah, so Alice and Shen.
Yeah.
Shen, yeah.
Okay, because again, it's in our code, besides the massage therapist license,
Mhm.
for a New York State registration certification for each employee. I think that's something different. I don't know if you have that and to prominently display that in your business.
Yeah, they have that license displayed by the counter.
That's great, but there seems to be a New York State registration certificate. Is that something different? And that's for each employee. It talked about the licenses and then it talked about the certificate. I am not that familiar with it, but I did see a different standard there. So
It does refer to both. It does refer
to both.
Okay, so I will find out New York registration certificate.
Yeah, yeah.
Okay.
Thank you. And then it also asked you to provide some information for the village police department. Were you aware of that? And
Sorry, can you say that one more time?
it says, according to our code, that the owner must, and anybody who works there must supply some information to the village police department.
Okay.
We don't need that information ourselves, but we would need confirmation that you've complied with that standard and have provided that to the village police department.
I see.
Well,
So they
Go
need
ahead.
to go to the police department and
Well, according to our village code, anybody on the board who's reading along with me, if I don't have this right, please correct me. But it does seem that the village police is supposed to have a phone number, your home address, your social security number, and fingerprints.
And all of that may have been done. There's,
Yeah.
there's nothing that says that you didn't, that
Right.
that the owner didn't actually do all of this and comply with everything. So that
I'll check whether that has all been done. Yeah.
Right,
okay.
so, and again, we don't need any of that information.
Right.
We need confirmation that it was completed.
When
Okay.
was this establishment, when was the former special permit issued?
3 years ago. So that was, I have it here.
2018.
November 1, 2018.
Yeah, Meg, I have a question for you. Where does it say that the signage has to be anywhere outside of the premises? It says here, shall display in a prominent place, visible to clients. The special use permit, no, this is, but shall have a visible signage indicating the existence of a commercial business. I don't understand what that means. And I wouldn't know. how
You're
to-
saying whether it's interior or exterior?
Yeah, I've never seen this before with anyone. I don't understand what that would
Yeah,
mean.
I took that to mean that, but I shouldn't have made the assumption. I made the assumption that it meant an exterior sign, but you tell me.
I think the concern, and I can tell you because I know when this came up in New York City, the concern that came up with respect to massage parlors was that it not be, and I remember we talked about some of this when this was here last time, the fact that it was clearly not a residential use. You didn't want it to be look like it was a residential premises, and that is what the goal of that provision is.
So I could, if I could then put the sign inside or by my door, inside the door. I'd need permission from my landlord. I'd need all this permission. We'd have signs all over the place every.
How about a sign in a window? You need permission to put an interior sign that shows through your window.
And the sign has to say what? This is a commercial.
It's a commercial space. It's to
Yeah, it's a
identify it as a
commercial
commercial business.
Right.
As I said, I think the sign is really just to make clear that it isn't a residential space, so it could
I'm
say
saying the sign-
massage, a massage business.
You don't have to say
It
that.
could say tranquil spa, and as I understand it, if you have the sign inside your window, you don't actually go to the BAR and you don't need to have a sign permit, but
Why
you
not?
could
Because
see
it
it from,
doesn't-
as I understand it, again, I could
But
be
it
wrong.
doesn't- I don't know where you're getting that it has to say what kind of a business it is. It says.
It just says
indicate-
that, no, I was just
commer-
making, I'm sorry. It needs to designate itself as a commercial space. I get offering that that's the name of their business. They could say Tranquil Spa. That's all.
Or they could say that commercial, this is a commercial business when you walk in.
Sure, sure. I thought it would be nice for them to say.
We can display it on the window.
So it's just, I looked this up and these are the standards for the special permit and I didn't see, that this had been complied with. And so perhaps you have, and you could just send it to us and show that it's all been complied with, it would be fine.
Okay.
I think it would be helpful for me if you took that provision 342-42.1 and just went through all the items and then addressed those items. And then we can just check it off.
Well, they have to comply with them.
So yeah, I think what following up with Meg's thing, if you would, and if you don't have a copy of this, we will make sure that our attorney sends you a copy of the standards. So he can send you a copy of the standards, and if you would just you can discuss with the owner, making sure if her English is not, I don't know if but if she doesn't understand,
I can help her out. Yeah.
Help her understand, and then have her go through everything that's in that list,
Okay.
and to confirm that she has done all of the things.
Right.
And if she hasn't done any of them, then go do them.
Right.
And if she has done all of them, then you can let us know that you have notified the police department, done X, Y, and Z, done all of the different things that it requires. And that's just you could come back, you could send us a letter, something that says you have done all of these things and indicate exactly what you've done.
So can I liaise with, I think Ashley was emailing with us after Amber has left. So can I ask Ashley for that code?
You could ask Ashley to send you the code. Madeline, if you would please let Ashley know, or if you could send it to her.
Yes, and the code is 342-42.1.
And yeah, so if you could send that to them so that they can.
342-42-1, sorry.
42.1.
.1, okay. Thank you.
We'll send you that.
That's all my questions. That's all I have to say.
Okay, anybody else have any questions? Does anybody from the public wish to address this application? Okay, so board members, shall we, what do you want to do? Shall we close the public? We have two choices, I think. We can close the public hearing, but not decide it subject to receiving a written letter from them, or we can leave it open so if they don't want to write it, they can come next time and tell us what it is. Let me ask the applicant, which would you prefer to do? Would you prefer to give us something in writing or prefer to come next time? And because we're not going to vote today on this. In either case, we wouldn't vote until we have.
But you can continue business because you have the light.
Right.
Yeah.
So
So the question is, do you want to do this verbally, like at the next meeting, or do you want to submit something in writing? Which is easier for you?
I think we'll submit something in writing. That's probably easier. So once we receive that code, we'll do a checklist and then say, we'll reply saying we've complied with everything. And if you need anything else, then we can submit any proof or anything else you need.
But we might have, questions about what they're going to submit. I don't think we should close yet.
Oh,
That's fine. I'm not saying we could close. I just wanted to know what we were.
Okay.
We could do what we don't have to close.
Right.
They can still submit a written too.
Okay.
Okay, so then if no one else has, if no one on the board and there's nobody from the public who wishes to address this, so you'll do that. So for the next meeting, if you would come back and you can submit it in writing is fine ahead of time. It's that's easy for you, so we don't have to go through everything at the meeting, and just submit it ahead of time. Ashley will talk to you, get back to you, and you can talk to Ashley about what it is. Because the next meeting is in 2 weeks.
Want to do November for them?
Well, I think if they can give, if Ashley sends it to them tomorrow and they have in fact complied with everything, I think there's no reason they can't be on the next agenda. Even if it's
Yeah,
in
if you
2
can
weeks.
put us on the next agenda,
Yeah,
and
if it turns out they haven't done it something and they have to do it, that might take more time. But I think if they've done everything and it's really just confirming it, they could do that in 2 weeks.
Okay.
All right. Okay, so then we will see you maybe hopefully in 2 weeks, and if not, then in November.
Thank you.
Thank you.
Good evening. Bye. Thank you very much.
Thank you.
Okay, so we have finished all the public hearings. I need a 2-minute break or 3-minute break. And then we'll start on the closed applications. There are only three closed applications, having removed many of these from the thing. So I need to take a.
You don't need to tell us. You can do whatever you'd like. Just get up special permit. I never saw this before. They do a criminal record search? Do they do that for teachers, educational? I would say.
No, it's because massage parlors have historically, not currently, but historically massage parlors were associated with
so let's call it's a massage service. They're a spa providing massage services.
Right.
They don't call themselves a massage.
Not because the term isn't used anymore, but historically, the thing called massage parlors was a front for a something that was providing something other than massage. And therefore, and that is absolutely true. There were huge issues of this all over and a lot of the massage establishments were in fact not really massage establishments. They were this other
Right.
And therefore all of these, I'm sure that's why they did it, because I know that's why they've done it in other places to reflect.
I would think though that doing a criminal background search with all respect on other establishments and owners would be probably just as important, or certainly particularly when children are involved with things, more so than when adults. That's just my own pet peeve. I don't quite understand that, but
there may be something in the teacher licensing. We don't have that in front of us. That's not our issue
no,
here.
no, but there are other, I understand. Well, we do schools.
We don't issue, but we don't look at the teachers. We don't say to the teachers.
I know we don't, because there's no requirement. I'm just saying that I know the Montessori school, other schools have been before us. Seems to me, I've got my grandchildren, I'd much rather have their teachers be checked than having people who do nails and massage. I mean, candidly, I think, but that's all right. I once had an issue with a music teacher and I said, I don't know why they're not licensed. I said, you're alone with my child. And I had a lot of problems with one of them. And I
see it
said,
a lot in you see it a lot in daycare establishments.
yeah, exactly. I completely agree. It just seems, I think Robin's correct in what she's talking about, but it just seems a little bit on the, I think daycare establishments are formed. If I had the choice, and I want to be clear about between having the people who work at a daycare establishment to take care of 4, 5, and 6 and 7-year-old kids or 3-year-old kids versus people who go with adults who are asking them for a massage, I would certainly opt for the daycare.
That's why I always get my babysitters from daycares, because I know they've already been background checked.
Cool. All right. You're taking a break? I got another. I take another pill from my mouth. Business. All right. Robin is Charlie. How are you? Everyone's gone. Okay.
I'm here. I'm good. How are you doing?
Bad day, but
yeah, I feel your pain with tooth stuff. I've had my number of dental issues.
When I was about 14 years old, I collected pennies and I threw this big jar of pennies up in the air to catch. And it was about, it must have been about 2 feet wide. And while it was in the air, my footing slipped and it came down on my face. And it just chipped one tooth, which was amazing because everybody thought I was going to lose them all. And that's been perfect since then. I had that one repaired. And today, everything went, oh, I guess yesterday, everything went awry. Such is life.
You got that right. Everything's unexpected.
Well, yeah, but the worst part was I went to see people and they go, well, we don't know what can be done. And I go, I'm sorry.
That's comforting.
You got it right, man. All they know is it's a lot of money and we don't have any clue if it can be repaired or what we can do. Aha. Sorry.
That almost sounds like when you go to a law office and try to ask for an opinion.
Well, that's interesting because we ended up having that discussion because I said to him, I respected that he's not a magician because, I said, honey, you ever get that I have clients, but such and such said he could assure me of that. I said, hire him.
Yeah.
It's like a car, right? Same thing.
That's right.
Right. How's your weather? Getting cooler up there now?
We've actually got the thunderstorm just started here. It's been cooler, but today was awful hot. And so we got something passing through.
Wow. We had a rough one down here.
I hear that. It's unbelievable.
Yeah, it was about as rough as, it was one of the saddest things I've ever seen in this village was you would go on our residential streets and they had trucks going by from the village to pick up stuff. People were putting sofas, furniture, carpeting. So
the last time we had something up here was Hurricane Irene, and it was upstate New York and Vermont got just absolutely destroyed because things kept rushing down from the mountains.
Right.
And it was uncontrolled. It wasn't so much the rain, but it was things coming down from the mountains that kind of did all the damage.
Yeah. There's a little river, we have Mamaroneck River. There's a little river that goes at the back of some shopping areas and parking lots. And you have to go up to the fence and you look down and you can see it sometimes. And it's a bad little thing. It's not something you'd see. And the day after, like all over, up on you could see it cresting over everything. And
yeah,
scary.
Is everything? Is all
I'm
the
gonna be
water
installing a sump pump tomorrow.
No, yeah.
I'm learning all of that. I've decided plumbing is my new vocation.
My grandfather taught me years ago, an Italian immigrant grandfather. He had a wet basement his entire life, and the sump pumps always failed and never worked. So then he created a little channel in his basement. So the water would come in, go through his basement, and go out the other. He said, why try to pump it out when I can just let it run right through the basement? It's a little, homemade engineering right there.
You got it. All right, I'll take a minute break. I'll be back.
All right, we'll see you soon.
Yeah, be well.
All right, board members, let me know when you're back, please, and we can reopen the meeting.
Nobody wants to sit all by themselves on Zoom, just like.
No, exactly. I'm company here, but whenever everybody's back, so just let me know is what I'm saying. So,
Like if anybody is watching the stream, it's like, oh, they're just watching me, just me on this.
I like your necklace, by the way.
Thanks. I actually, it's so, I so rarely get dressed up. I was like, oh, I'm gonna put a necklace on.
These days, you mean you so rarely get, yes.
World.
So wait, just waiting for David to come back.
Robin, are you moved?
All right. I was just saying, I see you're back. Okay, I guess we're all here. We can restart. We can re-go. We can continue. Everybody's ready? Okay. So the first closed application is 2SP 2020 419 Mamaroneck Avenue. So we have a draft resolution, I believe. I have to go find my draft resolutions.
Yeah. Robin, what is that one?
I don't know. I actually don't see it. Looking at all the open draft resolutions, and I don't see this one. Do we have, Charlie, do we have a draft resolution on this?
It was in the email that I had sent. I can pull it up and share the screen if everyone would like.
Yes, I missed it.
This is
419
Oh,
Mamaroneck.
that's the cafe.
Roaster Cafe, right. I'm sorry, I had all the others open. I must have missed this.
Same thing. Exactly. Ah, Charlie, I say, Charlie.
Would you like me to share the screen?
I don't, what board members, I mean, I'd rather just now that I'll just find it and look
Hey,
at
give
it.
me 1 second. I rather find my. There we go. Oh, no, Charlie. Which? Oh, here
He
we go.
sent it on,
Yeah, I got it here. I think I do. It's on the bottom, right, Chuck? Right? Yeah. No, it's not. It's not it.
yeah, it's all at the bottom of that email.
No, that's the jurisdiction. What? This was. Oh, okay. This is, you sent this on September 22.
Yeah, that sounds right.
Seems like a long time ago. No.
It does.
Okay. So which resolution? It's the Mamaroneck Avenue, right? Is that what you said, 419?
Yes.
No.
Yes.
Now there are two open items on this, according to the parcel history report. And the resolution said there were no open items. So that's
So we
an
did,
open question.
I don't know if it was on our agenda phone call or when it was, but we did speak with the building department and they had said that all violations had been closed.
But
Right.
did we vote on this?
We didn't vote on this. We just had a draft resolution.
Well, if you look at the draft.
That's an error. That's there.
When you say we, you mean you,
No, because it says here, yes, no's in the bottom.
That's just part of the template.
Oh, okay. Oh, it says yes and no. I'm sorry. I looked at the first one. You're right. I'm sorry, Charles. I saw yes, 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 and I went, huh?
Right.
But you have to go over. So it's yes or no, or abstain, or not here. Gotcha.
I don't know if anyone.
He has to come off of that because Abby's not here. So
Yeah, I will certainly take that off.
some of them had Abby on it, some of them didn't.
If anyone from the building department is still on. Doesn't look like it if I look at the attendees.
I thought they said at the last meeting, I thought we discussed this, and I thought what he said is that everything was closed, but that not everything had been removed or updated on this list. I thought they said that at the July.
That's what we had understood from the assistant building inspector last month.
Yeah, the last meeting.
okay,
right.
okay, so that's
For
what.
the last meeting, yeah. It was more than-
The July meeting. So he
Gotcha.
said they were closed, but he said that everything was resolved, but
Right.
it's a separate issue of removing or cleaning it up.
Okay,
So, okay.
all right.
I want to give it, so my only comment is I don't want to extend it. Given all of the issues, I would like to make it another 3-year resolution. I don't want to grant a permanent one yet.
Okay.
Um,
I have that in the resolution right now. This special use permit extension is granted for a term of 3 years from the date of this resolution. Should change that to renewal.
All right, it's confusing because it says and shall terminate upon a change of use, which implies that it is only terminates on the change of use, and then it says it's granted for a term of 3 years. I think you have to write it in a way that it's clear that it's a term of 3 years, but notwithstanding the term, it shall terminate upon a change of use, because otherwise it's a little
just
inconsistent, it's a little unclear.
Or just grant it for 3 years. Put that
Right,
right.
but if during those 3 years,
Yeah.
they tried to change the use, then it would be terminate. They don't have a permanent right to the 3 years. So I think it says for a term of 3 years, provided that the use does not change is what it is.
Yep, I can make that change.
Something like that. Now, we just had this long discussion about hours of operation, so let's make it clear what we mean by hours of operation. And based on what we've done in other resolutions, I think what we need to say is that all, basically, there shall be no, that all customers have to leave the premises after those hours, that you can't have customers on the premises beyond those hours. It says nothing about when they can clean or anything like that. We also need to have the provisions in here relating to closing windows and doors at 10 o'clock.
So that was only if you have music that we've done that. We've done 10 o'clock if you're playing music indoors. I was suggesting that if anybody is asking us for something beyond midnight, that could be maybe any occurrence. But
I understand, but I don't know if they're playing music and I don't know if they're going to, so I think we should just put it as a standard provision here and limit it to music. If there is music,
or amplification. We said amplified sound, which all includes music or amplified sound.
Yes, but just because they haven't, we don't know that they've done it to now, we don't want them to do it. So I think it's reasonable to put that in.
And I understand that we should consider this to be clear that, you know, what does the hours of operations mean? But here he's like a breakfast lunch. Do we really care if he has people that stay till 2 p.m. or 3 p.m.?
No, we don't care. It's really the nighttime that we care about.
Yeah, so.
But but I don't see how, I mean, if you have some good idea for how we can distinguish that, that's fine. If we want to say the hours of operation shall not be later than that past 10:30, there should be nobody on the premises on any, you know, whatever. We could say.
I have a hard time doing that. I'm actually getting one over that we should not be saying about what they do interior. I'm very fine with saying closing walls and doors and windows. I understand the argument that even when you open the door and you come out, but as a C2, the door leads to Mamaroneck Avenue and it closes at 10:30. I don't know.
I want to make this all consistent, so I would like to put in the operations, and the point has to do with the same principle, which is concerned about noise and impact on the community. And the fact that they don't need to be open later doesn't change it. It's still the same principle. If you want to say for here that given that, because we don't want to establish a precedent, so that 10:30 and then they just, so what does that mean? I think we need to leave.
Okay, but this one is 10:30 and across the street, he's going to be open till 1 if we grant it, or 12. Some people are open till midnight. Why would we tell him, oh, but you can't, you have to get all your customers out by 10:30 because it might be disruptive, but we've given it to 3 other people on Mamaroneck Avenue that
hasn't asked for it.
Sorry?
We have historically given applicants more or less, you know, we've sometimes shortened hours, what they've asked for. He's only asking till 10:30. If he wants to come back and ask for longer, that's fine.
I didn't quite finish. So what I was thinking was, if we want to have some standardization, if we think it's disruptive after midnight, we put that in for everybody. You can't have people, customers in your place of business past midnight or something like that. But if somebody's open till 10:30 and you have given out 3 or 4 to people that are open till 12, I think that's, why are we telling this person that you can't even clean or have a staff party?
We're not telling them they can't clean. We're telling them
you
they
keep
can't have
cutting me off
customers.
before I finished a sentence. It's a little bit distracting to my brain as I'm trying to make my point, Robin. So I am very reluctant to start saying that you have to chase people out at 10:30 because you said that's how you operate your business. If we want to try to do some standardization, like I said, like we usually do 10 o'clock for music and we're trying to be standardized, that seems fair to me. But to, you know, I mean, I don't know how we tell these people like one o'clock. What is the hour that the last time that somebody could be there? So you're not going to put a standard at the end of 1 p.m. They have to be out by 2, or they could be till 10. I'm just showing that it's a pretty difficult thing. And unless you're going to be a standardized time for everybody, and then we're starting to legislate if we say it's the same hour for everybody. So I have a real problem with trying to tell people like when they can clean. What if they wanted to renovate and paint their, you know, or move furniture around or something inside their space? And the best time to do it is between midnight and 1 in the morning. I really think that we're getting involved in their operations and preventing them from being able to run their business the way they should.
We have never told them when they could clean, and nothing here tells them when they could clean. Doesn't tell them when they can clean. It doesn't tell them when they can renovate. There are other things that limit that. All this tells them is when they could have customers and operate the business, business of providing food and beverages. That's what we're talking about, the operations, and that's all we've ever limited them to.
We have in the past indicated when people have to leave the premises.
We have
And
on
we've done that because sometimes people stay and they'll have a large crew working, and at night we've done it with restaurants, right by the station and by others, and usually they say then you have to close up within an hour so that it is, otherwise because part of the whole idea is that you're having people disturbed by it. So you can be disturbed by a large group, but certainly if you have, let's say 5 or 6 people that are deciding they're going to shampoo rugs and work all night, you know, you don't even do that in buildings in New York.
So we did that on the standard that customers need to leave an hour after the business operations close.
That's news. That would be different from what we've ever done before. To the extent that we've defined operation, it's always been defined by when customers had to leave. Dave's point is there are specific applications like the restaurant by the train station where we specifically did have some, and there were a couple others where we specifically limited the customers, the cleaning, because the noise was, carried and there was specific
Okay.
concerns.
But
So I don't
since we
think in
have
the
somewhere,
general, I don't think in the general we would want to do that.
since we have somewhere we specified, I wouldn't assume that because we said the hours of our operation are say until 10:30 PM, we did not say what we meant by it. Since we had somewhere we said when the customers could leave, I don't know for sure that that's what when I voted on this or someone else voted on it, were we all in agreement that that meant that customers have to leave by 10:30? Or was that when the business operations have to close? So I wouldn't make that assumption that's what this one and other ones say, or that's what board members intended when they voted on it. It's definitely ambiguous.
Well, it doesn't matter what board members intended when they voted on it last time, because we're voting it on it again, and we can determine what we want. So whether or not it was considered, now what we want to do, we can decide what we want to do. And if we don't want to limit the operations, that's something we don't have to do. But similarly,
So what I would like to do, I think is fair, is an hour after business operations end, because in that way, I don't think that we're inhibiting anybody from having to chase customers out and actually lose a customer because they have to chase people out. So I think an hour after the business operations is something that's reasonable.
I
don't even know that we have the right to do it.
Number one, I do think we have the right to do it if we're concerned about impact. There are, notwithstanding all the cases that Andrew mentioned, there are definitely cases the other way that do allow you to impose hours. So that's the first thing. The second thing is that I don't want to do a standard hour after. If we're telling them they have to, like, for example, this one closed at 10:30, but you're talking about general, something that's closing at 1 o'clock, I don't want to give them another hour. I think 1 o'clock is late enough. And if that's their business, and people know that they have to be out by 1, then they'll know that's what they have to be out. It's up to the restaurant to ensure that its customers know that, so it doesn't have the problem. The problem arises when customers don't know and all of a sudden they're there. So I think I don't want to do that as a
Okay, but in this instance,
maybe because it's earlier, if you want to allow it, I don't have a problem with that.
also because we don't have the applicant in front of us to clarify, do you know what we mean by this? By 10:30, we mean that you have to have all your customers out of the space. We don't have that person here, so there could lead to confusion because that he's taking a last order at 10:30 and doesn't realize he's supposed to have nobody sitting in his space at 10:30.
This is the same applicant that was on the Barkeela, and he said for Barkeela that he understood it to mean that.
No, but this is a different application, so.
I understand that, but I'm just saying what the applicant said he understood hours of operation to mean on that one, which also didn't say exactly what it meant. But anyway, that's fine. I'm okay with not necessarily, if you want to make it an hour, you make it. Greta and David, what do you think?
Yeah, I think both you and Meg make some valid points, but I think a good compromise is to add, to be, very specific in the resolution, but then to add an extra hour because it is really early and it seems unreasonable to enforce, 10:30, which could be interpreted ambiguously by this particular applicant, and to give neighboring establishments 2 or 3 extra hours of operation. So I think that sounds like a reasonable compromise.
So you're not saying for every application, you're saying for this one to give them the extra.
For this one.
Okay. I just wanted to.
And then when we have future applications, we have to have the conversation with each applicant.
Okay, that sounds reasonable to me. David?
Yeah, I'm good with what Greta said.
How do we describe what operations are then to make sure that it's correct and that what
Why don't we just say that the
kitchen has to close by that hour.
The business has to close. It's a commercial business and it's got to close.
Well, no, but we're not saying that. What we're saying is that, if I understand what has been said, is that at 10:30, since those are the hours of operations, those are the hours at which new customers can come in and the kitchen has to stop serving, and that they have an extra hour after 10:30 for the people to have to leave.
Well, you mean the customers or the people who work?
Customers.
Not the employees. The employees can stay all night?
We have not done anything about employees.
Oh, we have in the past with others.
I'm talking about here, these
Yeah,
particular ones.
How about instead of the kitchen closes, it's there's no more sales after this hours. No more
Yeah.
customers enter and no more sales of any products, drinks or.
Absolutely, it has to be, I agree. And that they have new customers, same thing. You can't have new customers coming in and no more, and the kitchen closes, and then they have an hour.
Yeah, but if you say the kitchen closes, then you have to say the bar closes or.
Oh, I'm sorry. I meant, you're right. You're right. You're right. I meant, when I said kitchen, I meant all food, but all the food and beverage
Sales
service.
have to end because you might actually have, prepackaged items and things that are sent.
Right.
So just so I'm clear, you only wanted that condition within the condition to apply to the Saturday and Sunday, because on Saturday and Sundays it closes at 10:30 p.m. and not the Monday through Friday where it closes at 1 p.m.
I think that's right. I don't think we care about the rest of the week.
Okay. And the other one was closing windows and doors at 10 p.m. if there's amplified sound.
Correct.
Or music. Music or because even acoustic music. Music or any kind of amplified sound.
Okay.
Thank you.
Okay. There are no other changes. The board may wish to take a motion to vote on the application, the renewal.
Yeah. You have to correct Meg. She's secretary, not vice chair.
Okay.
Okay, I'll make a motion to approve it as revised, to approve the resolution as revised in our discussion.
I'll second.
David?
Yep.
Greta?
Yes.
Meg?
Yes.
I vote yes as well.
Okay.
So it is approved with the changes. Wait, sorry, just give me a second. Okay, the next item on the agenda is case number, I'm looking for the case, where is it? We're taking this slightly, actually, that's all that, give me a second.
The next oldest one is the Beach Avenue.
I understand this, so I understand that's what I was looking for. We're taking this slightly out of order if there's anybody following the order. We're going to do 130 Beach Avenue, which doesn't have a case number. So it's just 130 Beach Avenue. And I believe that we have two draft resolutions, or we did just have the one revised. I don't remember what was circulated. Charlie, are both in the public notice, or just the one that as Meg had revised it? What is in the?
So the resolution that was prepared by my office was made publicly available, and I believe Meg asked Amber to also make her resolution available to the public. If not, she definitely asked it to be made available to the applicant. And I believe Amber did follow through on that.
I didn't ask for it to be, that's wrong. I just asked for it to be added to the agenda materials.
Okay, so they're both, so there are both, they're both there.
Robin, you sent one out today?
I didn't send one out. I had some comments which I'm going to discuss, but I didn't want to give it to you at the last, at the absolute last. I don't know that anyone had a chance to review it. So I'll discuss my comments here, but I did just want to, in case anyone wanted to read them ahead, ahead. I didn't mean to, because I know it was last minute. I didn't mean them to be. That's why I'm discussing it.
So in the interest of time, I would like to take like a little straw poll of our group here. Do we want to talk about the original resolution that Charlie's office had put together, or do you want to review the resolution that I put together?
I think we.
Greta, David?
Well, I could tell you that I have a lot of problems with the resolution as put together by Meg. I don't know that I agree with everything in Charlie, and the resolution is drafted by Charlie either. So we can, we can take up we can take a start with the resolution as put together by Meg, if that's what the rest of the board members want. You know, I have a problem with both of them. More
The
so
thing is
than-
that they're distinctly different in their findings, so I would think it would align with how people are finding it. It isn't just a language or a way to get
Correct.
that finding.
They are significantly different.
It makes a difference.
Correct. And I have a lot of problems with this one. I have fewer problems substantively with the one that Charlie prepared. David and Greta, what would you like to do given what Meg is asking, which is a reasonable question?
Oh, wasn't Meg present hers if you want? I'm not.
Yeah, I am happy looking at Meg's.
Yeah.
So we're gonna, okay, so then I will go through with my comments. I will give my comments first, and the rest of you can give your comments. So if you pull out Meg's, I will start with, whereas Unit B is comprised of approximately 2,400 square feet on 3 floors. I don't recall that we know that we have the survey of factual information. We certainly don't have it in this new application, given that this information is not in the application and the appeal that I don't believe it's in the application or appeal that was filed that we are faced with. Therefore, I don't think we can say that because we are solely dependent on the information provided in this application. So I think that has to be, I think we have to not say that.
Where are you referring? Could you revert by page or something?
The second whereas clause in Meg's revision says,
I see.
whereas Unit B at 130 Beach Avenue is comprised of approximately 2,400 square feet located on 3 floors. So the 2,400 square feet was not in anything that the applicant submitted at this point in time. And since that's all that's before us right now, what the applicant submitted and not the facts underlying the original application, I don't see how we can say this.
There's not, do we not know that it's 2,400 feet?
How do we know it?
I'm asking, how do we know?
We only know it because in the original application, the one that the board decided on that we approved, you know, that was approved, we may have had that information. I don't even remember. I didn't go back and look. So I don't know, but we are.
I'm sorry. Zoning board members are allowed to take into account their general knowledge of what's publicly available information. That's why they're local people and they can take it in. I thought the case authority is always on that.
But we usually have a survey when we make that. We have always said you need to give a survey. Obviously, no survey was provided here. So we're relying on something provided, some information. I don't remember.
But didn't we find that? Didn't the board find that in the past that it was 2,400?
I don't know. I don't know. That's what I'm saying.
It's what the applicant provided, but you're right. I don't know that we had a certified survey. So do you want to just say it's located on 3 floors? It's at 130 Beach Avenue, located on 3 floors.
And that's fine.
Problem here. If we don't have a certified survey note, so how do we know an address? How do we know this is really? I don't know. All right, go ahead. I'm sorry.
I will say
Nothing. I'm out. That's fine.
That 2,400 number was in the prior resolution.
Yeah.
And that is.
If it was in the prior resolution, then it could stay in here.
Yep, it is. I just checked it.
Yeah.
Okay, then it's okay to stay in here. Okay, next whereas clause. Whereas the property on which the premises is located is within the R5 zoning district, but the premises, it's not located on a legally pre-existing non-conforming use of a lot, because that's just not correct. It is, the premises is part of a legal non-conforming use consisting of a 2-family residential structure having 3 stories.
Right.
But it is not
the fact that there's a 3rd unit as well on the lot. That's what makes the whole lot use of the lot pre-existing non-conforming, because there's actually a secondary structure for the 3rd.
So then it should say as part of a legal non-conforming use consisting of 2 structures, one of which.
You just don't like use of a lot? That's the part?
Well, I have a problem with containing 3 dwelling units because you don't talk about structures there either. And the issue is it's 2 separate structures. So the whole structure point isn't there either. And it's not located on a pre-existing non-conforming use of a lot. It's located on a lot, but the use is not on. It's just, the language is just not right. So that we should say, but the premises is part of a legal non-conforming use consisting of 2 structures, of which the premises is a 2-family structure having 3 stories. So And I think that solves that problem. Okay,
Would you just say that just a little bit slower? Because I'm going to type track changes into
sure. The premise is part of a legal non-conforming use consisting of 2 residential structures, of which the premises are a 2-family residential structure having 3 stories.
You mean it's a lot that contains 2?
Yes, contains 2 structures. Yeah.
And the third unit is located in a separate garage structure. Can we add description?
Yes, that's there. That's fine.
Mhm.
Sure.
But is there a difference between now you have a definition of the premises and the building, and you're talking about the same thing. What is unit B is the 3rd floor? What is unit B?
No, unit B is 3 stories. It's a half of the building, and the other half also has, I believe, 3 stories. I don't know, 2 stories or 3 stories in the other.
Well, because then if the premises, and just to clarify something, if the premises, i.e. the unit as to which the application relates, right, Mr. Teichert's unit, if Mr. Teichert's unit, I believe Mr. Teichert's unit is on 2 stories, not 3 stories. Am I wrong?
Yes.
Mr. Teichert's unit is on 3 floors?
Yes, you come in on the ground floor, then you go up and there's some area there, and then you go up some stairs and there is the area that we all know Mr. Teichert.
Right, and
then there's another story that goes up to a 3rd.
Correct, but I'm sorry, Meg, let me just, that's where it's confusing. I thought that the building in which Mr. Teichert's unit is located has 2 separate dwelling units. One dwelling unit is the 1st story, and a separate dwelling unit is the 2nd and 3rd floor.
No, there are 2 different entrances. And so one is 3 stacked, 3 stories, and then around another part of the building. Wow, sorry. And does anybody hear that? I have something going on outside my residence. Firecrackers.
Oh.
I hope it's firecrackers and not.
You have to hurry up and vote before God forbid something, huh?
Sorry, that's distracting.
So you're saying that both units are 3 stories?
Yes, they're stacked and they have completely separate entrances.
Okay. I guess I've never, maybe because I didn't pay focus on the other unit. Okay, so the premises is
his
part of a legal non-conforming, is located on a lot. So it's located on a lot which has so the premises is located on a lot which has a legal non-conforming 3-family use.
Plus a unit, which is also non-conforming to have the 2 buildings on the same lot. So I was
right, so which is
paying attention to that. That's why the lot, it was the use of the lot is pre-existing non-conforming.
Gotcha.
But it's not located on it's not located on a non-conforming use of a lot. It is a non-conforming.
It is a non-conforming
part of a non-conforming use of a lot. That's the problem. It's part of a non-conforming lot, use of a lot.
It's a property that has non-conforming uses on it, comprised of.
Right. That's what I was trying to say.
Yeah.
Yes.
Yeah, right.
Exactly.
So should I read what I have based on the discussion? The property on which the premises is located is within the R5 zoning district, which permits 1-family dwellings, but the premises is located on a lot which has a legal non-conforming 3-family use.
Located in 2 structures.
Located in
pre-existing. It's not a legal existing, but I think, I don't know if you put pre-existing in there.
No, you don't need to. If it's a legal non-conforming use, then the fact that it's a legal non-conforming use means it's pre-existing by definition. You don't need to say legal pre-existing. Once you say legal non-conforming use, that automatically tells you it's pre-existing because it
Now,
can't
what
be
were the words
non-conforming.
after that? Charlie, you were just reading, I'm sorry, what was the word?
So a legal non-conforming three-family use located in two structures consisting of two residential.
I don't think you need to say that. It's located consisting of,
Two structures,
two
one of which is a
structures.
two-family and one of which is a one-family,
correct.
right?
And
That's-
that the premises are part of the two-family residential structure, which has 3 stories.
Okay, hang on, there's a lot to follow here. Consisting, so I have, is located on a lot which has a legal non-conforming three-family use consisting of two structures.
comprised.
2 residential structures, make it clear it's residential.
2 residential structures.
One of which is a two-family.
One of which is a two-family.
And the other, by mathematical deduction, is a one-family. You can leave the middle out.
Family.
Yeah, and the other is a one-family.
Okay. And then.
And she wants to know where the premises are located, right? The premises are located in the.
That's a defined term then as the building. And a third unit is located in a separate garage structure. Okay.
Is it a garage?
It was a garage.
It was a garage, it's no longer.
I mean, I wouldn't call it a garage structure.
A
because
separate structure, a separate structure.
Okay, got it.
Okay, then moving on to the whereas clause on the second page, which I think it was on the second page, it might have moved, whereas the applicant appealed the NOVs.
Yep.
It should be the applicant appealed 5 of the NOVs. He did not appeal 2 of the NOVs. So he only appealed 5 of those NOVs. And the board made the following decision dated September 10th, 2020, a copy of which is attached here too. We're referring to this, let's attach a copy. Because that's the basis for us deciding anything. Then going through those things. So the first one denied the appeal and listed the appeals that it denied. It also did something else. It determined that the use of the 3rd floor of the premises was an illegal 3rd dwelling unit. It said that. And if we're going to say what it did, then we have to say that it determined that the use of the 3rd floor of the premises was an
Robin,
illegal.
is that a direct quote?
It says it. It says it was the use of the 3rd.
Sorry, that's not my answer to my question. Is that the exact wording that you have in your resolution?
I have to open the resolution and I will look. Have to find the resolution. I looked at the resolution when I was reviewing this, but I don't have it open in front of me, so I'll have to find it. I can find it.
I can read it if you'd like. I have the provision in front of me.
Yeah, and also I don't
know if we want to.
It's just simply saying what was the status of each of these appeals. You're trying to add, you're adding some interpretation of, you are adding.
You're attaching it and you're going like that.
I'm not adding an interpretation. I'm giving.
You're adding a finding. Rather, what I'm doing is just stating what was denied, what was upheld to clarify that. You're adding more information, which I chose not to put there.
Well, it seems to me that by choosing not to do it and the rest of the sense of this resolution, you are eliminating, because you're leaving out some of the important and what is relevant to some of the findings that you are not then discussing in here.
Except you're attaching it, Rob. You've asked that it be attached. So, I mean, if you're going to attach and when we could write it all out, I mean, I think, say it was, you want to attach, I've never seen it attached, but you want to attach it? Fine, but I think it's a lot of, it speaks for itself at this point.
Okay, I mean, we'll do what we, if the board doesn't want to do it, I'm just, this is my
I got it. Go, keep going.
Okay, with respect to point number 2, granted the
Okay,
applicant.
we didn't get past number 1, so I don't agree with that change for number 1. So I don't know how anybody else feels, but I think the way that I originally wrote it is fine, and I don't want to.
Which is number 1?
Determine this to deny the appeal of those 1, 2, 3, 4 NOVs.
Yeah, I like that. That's what happened.
The next one is granted the applicant's appeal. You don't grant it an appeal to, it's an appeal of, but
Were there changes to number 1?
no, the board doesn't like them. I think the board is, but anyway, granted the applicant's appeal of and found that the property on which the premises is located. Now, the board's resolution did not simply say it had not lost its status as a pre-existing legal non-conforming status. The resolution said that did not lose its legal non-conforming status as long as the applicant remedies the illegal alterations to eliminate the separate dwelling.
That's fine. That's fine.
I think that
want to just do it consistent with the other one.
Because it's not consistent, because we're making a statement.
I know, but if you want to just end it after 5/8, is that okay?
End it where we've already.
It was just because it was the reason why, let me just explain. The reason why I did this was because it was confusing. The appeals and the numbers got confused in the original resolution. So I was pointing this one out because it actually had gotten flipped in the original resolution.
Okay, I got you.
So that's why I had highlighted the.
So Meg, you have no problem with that change then?
I don't have a problem with number 2.
We could just go over.
It helps to clarify what was the error in the original.
Right, gotcha. Okay.
We could just go over in a slower manner what that change was. I'll write it down.
It would be granted the applicant's appeal of the NOV and found that the property on which the premises is located did not lose its legal non-conforming status as a 3-family property, quote, as long as the applicant remedies the illegal alterations to eliminate the separate dwelling unit, close quote.
Okay, so I got the quote as long as the property, and then I lost it because I couldn't type that fast.
If you look at what I circulated, it's right in there.
Okay, perfect.
If you did, Robin, quick question. If it was altered, does it lose its status? Does it revert? Does it lose its prior non-conforming status?
I'm not sure what is altered, as long as it remedies the illegal alterations. That's what the resolution says. So if they didn't remedy illegal alterations, whatever those remedies are, which is what the issue is here, then it loses its 3-family status. Yes, it has to remedy the illegal alterations.
But what's the grounds? If it runs with the land, how does that happen? I'm just asking.
How does what runs?
How does it go back to it lose its status? I can understand if it.
I can't answer the question, David.
Let me explain. If it does something improper, you can say it's a violation. It's got to be changed. But does it lose its status as a 2-family or multifamily if it has a violation?
I'm not answering that question. This is what the board resolution said.
Okay. Oh, fair enough.
I'm just giving you.
That's fine. You're right. Thank you.
You're asking a good question, and I'm not. I don't want to think about the answer right now because that's a really good question. But
I'm good.
But I'm not going there. Okay. Then the 3 is then the 3 is fine. Then I added a new language, whereas the board did not specify the changes that the applicant needed to make to the unit to comply with the village's zoning code, because we didn't. That resolution didn't, and I want to say that. I mean, that's the whole key here. The board didn't make that determination.
Okay.
Is that also in your draft, Robin?
Yes.
Okay.
I'm just reading from my draft and explaining where necessary.
I got you.
Okay, great.
Okay, then there is a section.
What does Meg say about Meg? Could you respond to that? So why don't we just do this in Syrian? We don't have to go back over this all.
No, actually, that was an addition. That's fine with me. That's addition.
Okay.
Okay.
I'm
Then
checking, I guess, what I did.
the resolution had in it a definition of dwelling unit. And I don't think.
Why do you want to take out the?
And that's, let me finish, Meg, please. And it also talks about accessory use. And I don't think either of those are relevant because those go to whether or not there is an illegal unit or not. And the board determined it was an illegal unit. So I don't think anything relating to the definition of dwelling unit or other or accessory uses is relevant to this decision, because all that's being appealed is, given that the resolution said that this was an illegal third unit, an illegal unit on the third floor, how does the applicant remedy that? And so everything having to do with what is the definition of dwelling unit does not appropriately belong here.
Well, it
And I
would
think
go.
delete it.
You know how to remedy it if you don't know what it is you're trying.
Right.
We made that decision. We
No,
said,
no, no, you made the decision that it is, yes, and that it has to be remedied. And then we're going through this saying, this is what has to change to remedy it, but you have to have the reference to say what the zoning code describes when you're remedying it. Otherwise, that doesn't make any sense to me at all. This whole resolution and what was being appealed, what the building inspector had requested was, I thought, purportedly to make sure it brought into compliance in terms of no longer being a separate dwelling unit. You would need to have the definition of units. And also because I've added the accessory about rumors and borders, because the building inspector went into where someone is supposed to live. Otherwise, I don't know that
Yeah, this goes to the, I
is
agree with
relevant
Meg.
to
This
what
goes to
was
the
being
remedy.
appealed.
I don't know that, so I have less of a problem with the definition of dwelling unit, but I have an absolute problem with the permitted accessory use, because that doesn't go to what they have to remedy. This is what a dwelling unit is. And to the extent you're saying that you can have two rumors or borders, which the resolution specifically found this was not. So we can't say, if you're saying that the board found in its resolution that these were not rumors or borders. That's what the resolution said. So if we're now saying you can have rumors or borders, that's irrelevant because the board found you couldn't have, that this was not rumors or
Robin,
borders.
we don't agree, so we have to go to other board members. I believe that it said that they didn't find they were akin to something. To me, that if it was not a rumor or border, the resolution did not say this person is not meeting the standard of a rumor or a border. And it does not say that.
There was a lot of discussion.
Sorry, I'll just finish first.
Yeah, sorry.
I think we all understand your point of view. I think we go to the other board members and see how they want to feel, whether they feel that it's inappropriate to put this piece of the code in there referring to rumors and borders.
I think it's a very appropriate because it goes to the remedy. It goes to if they're going to make it a non-board. You can't remedy it without saying, okay, it's got to be illegal. You got to get rid of the, as Robin said at the beginning, as long as you get rid of the illegal use, etc. Well, here you're saying what the uses are. I don't understand. It's just a quote from the code. Just like Robin, you wanted an attachment. I don't know. I mean, I think lay it out. It's there. It is what it is. We're not talking about relevance. That's what the code says. How can you discuss dwelling unit? It's misleading to suggest it's a single family dwelling, period. No, and it allows borders and rooms. Why? I have no idea, but that's what the code does. So I wouldn't know that, but for the dwelling unit, but for saying it. I don't see how it's not swaying anything. It's not determining anything. So that's my view. Anyway.
All right.
Why would you cut out, just as we corrected what was wrong about the reference numbers, there's nothing wrong to explain. That was very misconstrued in a quote started with dwelling unit, never ended a quote and went into another piece of the code afterwards. I do think it's relevant to explain that because it was misleading in that other resolution, just as the errors and the violation numbers got mixed up. There was something left out when you tried to, you just didn't close a quote or something about dwelling unit. We should clarify that.
I don't think it's relevant to this. I think you've now included the definition. The fact that the board decision only cited only a portion is not relevant to the fact. We've got the whole quote here, whether it did or didn't. The resolution also discussed a lot about what were rumors or borders. There were a lot of discussion. So I don't know that there's a reason for the footnote. It's not a big deal. It seems to me just irrelevant and not necessary. But
I would like to keep the footnote in.
Now you talk later on. It's
yeah, I don't. So now you want to add
information about the.
We don't have to. I thought in here I read, and now I'm reading it again, and it's not there. I thought you talked in here, and it's not here, so we can take that out. I thought in here you discussed the appeal to the appeal to the court. If you don't discuss the appeal to the court, yes, you do. You do discuss the appeal to the court, and so if you're discussing the appeal to the court, then I don't see why we don't also discuss the appeal to the Department of State. Why are we discussing one
Because
appeal but not the other?
on the building code violations. It's not about zoning.
No, actually, the application was an appeal of the zoning code. That's how the
It
application.
can possibly be. You don't go where the applicant went with that was on the building violation. It was
Actually,
a single paper on it.
obviously no. I'm sorry. I really think you're really off the mark here, Robin. That appeal was about the building code, and as I understand it, that the response was you have zoning violations. You need to clear those up, and then we can talk to you about the building code. But it was no. He was not. The applicant was not asking for an interpretation of zoning. So this is completely inappropriate. It's not necessary. I don't know why this is here.
okay, now to correct what you just said, the actual resolution did not appeal it sort of appealed both. And what the Department of State said was that it had no authority to decide appeals relating to the village's zoning laws. And what the application said is these codes say that it is something about the building code, and therefore the zoning resolution they have to allow us to be there under the zoning code. So it was an appeal of both so it wasn't just an appeal of the building code, it was an appeal of the building code, and therefore it is a legal use and it can stay there. And the Department of State said no.
Let's keep going. I disagree. I want to.
I'm still going to disagree with most of my comments, but that's besides the point.
Okay, so I would.
Excuse me, was the building code, were the papers on the building code violation in the record here?
They were distributed, I thought, to all the board members at some point.
I have no idea. I've never seen them.
One was the no electrical permit and no work done without an electric permit and work done without a plumbing permit, I think. Was the other
No,
one.
it was much more than that. It was, it had to do with definition of what, it had to do with a lot of the definitions.
I thought that the two that you said that we did not review were those ones with the.
No, it's not what it was. It was more. It was much broader than just the two.
But anyway,
I don't know. I don't have it now in front of me.
Okay, so I don't accept this. If I would hear from Greta and David, if you feel that it's important that we discuss appealing to the New York Department of State about building code violations, if you think that should be in here, but I don't.
But as I said, it wasn't an appeal of the building.
We heard you, Robert, but then we're hearing from me and I don't agree and I would like to take it out. Greta, David?
Greta?
Well, I mean, do we, Robin's kind of contradicted herself at one point. She said it wasn't included in the rest of the resolution, and then she said it was. So where's the reference in the resolution to why you would have it in the first place?
I'm sorry, I didn't say anything about wasn't included in the resolution.
No, earlier you made comment.
I said I didn't remember where the appeal, I knew that this had mentioned the appeal to the court, and if we were talking about the appeal to the court, and I couldn't find it, and then because I thought it was after, but it was before this, and then I said, oh no, it's there, the appeal to the court, and because following the appeal to the court, I wanted to put in the other appeal. That was why.
Yeah, but I don't think that's got any, I haven't seen those papers, so I'm not gonna, I don't find the relevance. We're just
Can't find it, so I don't know. I thought it was distributed to all the board members.
No, I never saw it. I've never seen it. I don't know the paperwork on it. I don't know what was the issues, what the jurisdictions were. All I know is this doesn't seem relevant to anything we did.
That's fine. Yeah. You'll do what you want. Okay. Moving on to the determination.
Yep.
So the first, with your apply architectural drawing showing the partial second floor stair and landing. And there's a language in there that says this finding is not relevant to the 2020 board decision. I'm not sure what that means, and I think it is relevant, but I just don't think that, I think that's a building code determination that it shouldn't be. I don't think that sentence is necessary. I think that sentence should come out.
I think we're both saying the same thing, that it's talking about what's required in terms of the building code, and which is nothing that we are reviewing, and it was nothing that had to do with the 2020 resolution.
But I don't know that it's relevant. I don't want to say it's not relevant. I'm not sure that it's not relevant. All these things are relevant to what was decided. It's just that it's not something that the board should be deciding because it's a building code question.
Well, you
So
could say it's not within the purview of this board.
That's fine. I'm fine with saying it's not within the purview of this board, but I don't want to say it's not relevant. Because I don't.
It's not within the findings of this.
Where are you getting? Can you? I must be tracking the wrong one.
Okay, we're on page 4, down the towards the bottom of.
It's got the list of the October, after the now therefore be it resolved. The board
Are you looking at Robin's markup that she sent us?
I'm looking at Greta's, which has my markup on it, but I'm sorry, I'm looking at Meg's. If you just look at
She sent something like at 7 o'clock tonight.
At 6 o'clock, I think, yeah, something like that. Yeah, I just gave it because I thought that, just so you'd have it, but.
No, it's handy to have it.
So that's why I circulate. Otherwise, I could have just circulated it like, sometimes at this, but I thought you'd have it ahead of time.
You'll find it a lot easier to follow the discussion if you look at it.
Yeah, but if you don't have that, David, if you just go to, and you have Meg's in front of you, then if you go to on page 4 where it says the October determination, the first one is building inspector determination.
Right.
And
I'm there. I got that. Okay.
And so instead of the finding is not relevant, I think it's to say that this is not within the purview of the ZBA. I think that would be appropriate.
Should we state why it's not within the purview? So something I just thought of was the determination as to the requirements for a building permit for walls and doors is not before the board because it is not within the jurisdiction of this board as it relates to the New York State Building Code.
I think that's fine.
Well, to the extent that it relates to the building code.
Well, what they have to submit is part of the building code requirement. It is or isn't. It relates to that. What if they are is not. We don't know. Okay, moving on to building inspector determination. So number 2, relating to the 220 floor outlets. So
I truly don't understand the sentence that you.
I'm going to explain. I'm happy to explain it. That as the resolution said, the board finds that consistent with the existing 220 volt outlet, could be used to of a non-portable stove. What the resolution said is that you could do a lot of things, and the whole issue came up as long as it's not used as a separate dwelling unit. So all of this is okay, provided that the 3rd floor is not a separate dwelling unit. If it is a separate dwelling unit, you can't do this. That's what the resolution.
We're trying to find the changes or alterations or different uses to make it not a separate dwelling unit. To just say, and don't use it as a separate dwelling unit is not helping the cause. We are talking here, the building inspector said you have to remove the electric line. What I suggest is that I agree that there was some concern because it was raised that it can be used for a stove and or oven. And so that it has to be clear that it cannot be used for that. But it either you can't use it or you can. It's not, provided the 3rd floor is not otherwise used as a separate dwelling unit. It's what makes it a separate dwelling unit. It's not like if it's not there and somebody uses it, it just doesn't, it's just superfluous. It doesn't provide any substance to say, provided the 3rd floor is not otherwise used as a separate dwelling unit.
Yeah.
Well, but I don't agree.
I just don't understand the logic of putting that in there.
Okay, the fact that you have a 220 volt electric line tells you nothing about whether it's a separate dwelling unit or not. Right? It tells you nothing about
Right.
whether it's a separate dwelling. So wait,
Well, excuse me, but that's what the building inspector found.
Well, why didn't he tell him to rip out the?
Yeah, why did he tell him to rip it out then?
because at the board had all this discussion about the fact,
All right.
and it was there, about whether or not there was a stove and whether or not you could put a stove in. And one of the issues that some of the board members raised was, as long as it was, well, since there's no stove, it clearly can't be complete cooking facilities. And so the question was, what if there is a 220 volt line, but no stove, is that okay? Or even if you could just stick the stove in and while nobody's watching, and that was the issue. So that was the whole issue that came up, because if there's a 220 volt line that's not connected to anything, that's fine. But if the 220 volt line is connected to something, maybe it is a problem. And the issue was whether or not it's a separate dwelling unit. So just to say it's okay to have a 220 volt line also is eliminating the concern that exists.
Yeah, but there's
Yeah,
always
I
a
think
concern.
there's
There's always a concern.
220 volt line.
But there's always a concern. That's like saying you can have a knife as long as you don't kill somebody with it.
It's always a
I'm sorry,
concern.
I don't get it, okay? I really don't. I can have a
220 volt line is
as far as I'm concerned, I
compliant.
can have 2 kitchens in my home. I had 2 kitchens in my home. I'm allowed to. If I can have a little bar kitchen and another one, does that mean I can't have a border because I have 2 kitchens? One small, I don't even think so. I think this is, but you don't want my, anyway.
I see
I
that
don't
the,
understand, because you're saying the board wants the 220 volt?
The issue was discussed a lot. It was a big issue relating
I know,
to.
I know.
Madeline, the hearing is closed. We can't speak to anybody.
okay,
Was somebody trying to speak?
the building inspector is trying to speak.
No, you can't.
No. The building department was an adversarial party.
Yeah, and this one I wouldn't take the building department. I think that's right. Given that the appeal is of something the building
To
department.
me,
I think
I was
that's-
clear in what I was writing. If you want to change some words.
You're saying it's not
It
installed.
was clear that a 220 volt by itself is fine. There's nothing in the zoning code that says you can't have a 220 volt.
There's nothing in the zoning code.
Excuse me, there's nothing in the zoning code that says you can't have 20 volt. Maybe you have an extra great air conditioner, or I don't know what hobby you have and you need a 220 volt line. It's nobody else's business.
I have a 220 volt.
If you're going to install permanent cooking, a stove and an oven attached to it, that's the part that's the problem.
Right.
We don't have jurisdiction to tell somebody, because we think you might be a bad actor, you can't have electricity like everybody else does in the village. We're going to take that right away. We don't have the right.
Meg, my dryer is a 220 volt, so I couldn't have my dryer then, right?
I'm sorry, I'm not saying that it is. I don't know why you're all interpreting that. All I said is
Wow.
it's not a separate dwelling unit. Otherwise, I have no problem with it. Now,
No, but
that's
you're
fine.
saying you're conditioning it upon,
I'm not conditioning it upon it. I'm saying
not
if it's a
required,
separate
but
dwelling
condition
unit.
is this finding on the applicant not installing. Come on, a non, all right, I don't know. I'm getting lost.
Now, the board finds
Basically-
that the 200, which should be 220, but the board finds that the 200 volt line is in itself is zoning compliant. The zoning resolution says nothing about 220 volt lines or any lines, and so that sentence is just wrong. The zoning code does not discuss electric lines. That sentence is wrong, and we shouldn't say it.
Which is the
It is
sentence?
not zoning
Okay,
compliant.
so the board finds no evidence that the 220 volt line is not zoning non-compliant, then I will change it.
Wait a minute, the board finds that.
Find any evidence that a 220 volt
No,
line.
the 220 volt line has nothing to do with zoning, therefore it has nothing to do with zoning code.
Well, it is, excuse me, the zoning code does not prohibit a 220 line, is that correct?
Correct, you can say
Then
that.
it. Say that.
Because
Say it.
he's telling
Okay,
him
the
to
board
rip out
finds-
he's telling him to rip out the electric.
Right.
make it
If you
zoning
want to say what Dave says, that's fine. The board finds
that the
there's nothing
zoning
in the
code
zoning.
does not prohibit a 220
that's
volt
fine.
line.
So I will
That's
say the
fine.
board cannot find anything in the zoning code. You can say that in better words than
Well,
me.
yeah, but say it directly. It
I
doesn't,
think the way Dave said it is the best way to say it.
I mean, it doesn't, the code does not prohibit a 220 volt line in the dwelling
That's the
unit.
best way to say it.
Meg, am I
That's
wrong?
the
Is that hurting you?
statement.
I don't want to.
That's fine. So I would like to take out, provided that the third floor does not otherwise used as a separate dwelling unit. That is not the point of what we are finding here. And that we say that, as Dave said better than what I said, that Say it again, Dave. Say it again, Dave. Sounds like
Oh, God.
Sing it again.
Late. I'm gonna defer to Greg. No, just get the
And
code.
it should be 220. That's a typo.
Nothing in the code prohibits a 220 volt line.
That's fine.
And I
Period.
would like to confess I have one. You can put that in there too.
I think that's
Locks on
fine.
my
I think
bathroom
that
door.
sentence is fine.
I have locks on some of my doors, and I intend to keep them. Deutschland über alles.
Um,
Enough of this.
okay.
Sorry.
Going on to number 3. In the middle of number 3, it says the board finds that a food consumption area is zoning compliant absent permanently installed non-portable cooking facilities. That is completely inconsistent with what the resolution said. There was no permanently installed non-portable cooking facilities as currently operated on the 3rd floor. Nevertheless, the board found that it was a separate dwelling unit. Therefore, to put this sentence in would be overturning the decision of the board, and we do not have that authority. So that sentence should absolutely come out. It is completely inconsistent with the resolution.
The board, go ahead, Meg.
No, you go ahead. I've been talking a lot, Greta.
No, I was just gonna say that resolution was based on the totality of the circumstances. There wasn't one factor that determined what made an illegal dwelling unit. So it is permissible to make this interpretation because that resolution was vague, purposely vague, on what constituted material factors. So this I don't find this at all inconsistent.
Want to put down the board finds it implicit in the 220?
We know that at the time, there were no permanent cooking facilities, no, whatever the sentence is here. We know that those did not exist at the time. Nevertheless, even though the board knew that that wasn't there, it found it to be a 3rd dwelling unit. There was a lot of discussion. There was a lot of discussion about the fact that whether or not a stove was needed. The 2 board members who, Megan and Greta, you both discussed and tried and said at the hearing that at the prior resolution, that the fact that there was no stove, a stove was necessary in order to make it a separate dwelling unit, and the other board members did not agree that a separate.
I disagree with you, Rob.
necessary.
I disagree with you. I was there for the deliberations, and it was never that explicit. You guys never actually talked exactly what was required. You didn't. We could go back to the recordings, but that was never you're saying that now, but that was not. That was explicit.
And I disagree with you completely.
Okay, but I disagree. So let's not. We'll stand.
Meg, what about does it do you justice to say the board finds it implicit in the 2000? Forget it. Whatever.
We're not arguing about the fact that it identified that this area was a food consumption area. It also found a lot of things. It that somebody took pictures and it found this and found, whereas a food consumption area was constructed. It did not say, whereas a food consumption area was constructed, that constitutes a 3rd dwelling unit. It did not say that. It had a lot of whereases of what it had discovered. And at the end, it made a determination that it was a 3rd dwelling unit. But we're telling people that you can't have a bar, like Dave says. You can't have a little refrigerator and a sink and a countertop and, with a coffee maker on top of it, a food consumption area. As most people I talk to, everybody said, like, I have a lot of food consumption areas in my house. Food consumption areas are not something that is prohibited by the code.
What the resolution said was that he clearly maintains his own household on the upper floor in space that provides complete housekeeping and sanitary facilities. Now, I will say that there was no stove on the premises. So given that the board found that what he had right there, what he had at the time was complete housekeeping and facilities, even though there was no stove, to say now that the fact that he had no stove means that it couldn't be a separate dwelling unit is overturning that decision. It's just wrong. You are the board, by adopting resolution that says this, is essentially doing is overturning that decision. You are taking a specific provision, i.e. the board found there were complete housekeeping facilities on the 3rd floor. There was no permanently installed non-portable cooking facilities. Therefore, to now say that the fact that he doesn't have a permanently installed
Robin,
non-portable
So then why was
Robin,
it
in your
required?
affidavit,
something
in your
that he never
affidavit,
had, you are saying that
Okay,
it
so
is.
Robin,
You know what?
in your
It doesn't
affidavit-
matter. You're all, it's all, I'm going to continue.
okay, but Robin,
Meg, I'd
can
like,
I ask a
Meg,
question for you? In your affidavit that you supplied for the appeal of the resolution, you put in that it had portable cooking and that was sufficient. So was that in the minds of people when the majority opinion said there was complete housekeeping facilities, it did not delineate it was no stove or oven or what it was that created the complete housekeeping facilities?
Correct. But you are saying now, here's the problem. If you are saying now that the fact that you don't have permanently installed non-portable cooking facilities means that it is not a separate dwelling unit. And I'm saying that is the condition that exists now. So you are saying he doesn't have to do anything to his unit. And you know what? You and I agree, because what it looks like to me, and I'm going to say this, is that the board members who lost the 2 votes now seem to have a majority, and you are essentially overturning the decision of the ZBA in the 2020 decision. You are essentially overturning everything that was found and everything that was decided. So I will continue to go through my comments. I understand that none of you are going to accept them, but I will make my point, and then you can make the resolution as you want without these changes, and I will vote no. So let me finish
Okay, so
rather
then-
than going through these in details.
Robin, may
The
I say
next one,
thing?
Dave has a
I'll be
comment.
very brief. Robin, I think you should go through them all. And I just want to say for the record that I think your assertion that we're completely overturning it is erroneous, and it's certainly your position. I just don't think it's right to say that's what we've all agreed upon. But that's fine.
Okay. Okay, Dave, that's fine. That's what this is, how I perceive it. And if you don't,
Oh,
that's
I'm
fine.
sorry. Perceptions, and I don't those two one, and I didn't even vote on this, did I? In the past, I wasn't on the board, right?
No, you aren't. Okay.
Right. So it's not
The
that I'm sorry. Okay, go ahead.
The board finds that the 2020 decision did not determine that wall and base kitchen cabinetry contributed to the creation of an illegal dwelling, and no revision to these furnishings are required. This is again inconsistent with the same statement. Essentially what we're saying is he can keep the housekeeping facilities the way he kept them, and he doesn't have to make any changes, and it's not a separate dwelling unit. Well, that's completely, in my mind, that's overturning it. The same thing, the next one has to do with exposing penetrations. The applicant did not appeal the 2019 violation that related to illegal work. So if the building inspector believes that removal of the sheetrock is necessary to evaluate the illegal work, I don't understand why we're telling him otherwise. If the building inspector thinks he needs to look at something, we did not make that decision. That was not part of our decision. He didn't appeal it. I don't know why we would be saying,
We're talking about
telling the building inspector what he does or doesn't have to do.
We're not talking about illegal work in terms of building code. We're talking about, is that necessary to make this remedy the separate dwelling unit? So we're not talking about whether or not he needs to open a wall in terms of looking at electrical work. That's not at all what we're talking about. If what we're talking about is that, and I think we make a disclaimer that this has nothing to do with what is required for building code compliance. We're talking in terms of coming into zoning compliance. There's no reason to be caulking these things or opening them up. That has nothing to do with zoning.
Okay, going to the next one.
Should there be a change to number 5 then to that effect?
No.
The next one says, although the 2020 board decision includes an assertion by the village code of enforcement officer that a wall and door had been installed, the board clarifies and notes that a site plan has never been provided to the board and that the walls, et cetera, et cetera. This is again, I don't believe that was provided, whether or not it was provided, and it certainly wasn't provided in connection with these applications. Now, this is all again relitigating the prior decision. Then it says that the board finds the stairway wells to be a pre-existing condition at the time of the applicant's purchase. The fact that something is an existing condition at the time the applicant bought the property doesn't make it a legal non-conforming use. Just because I bought a piece of property which has an illegal condition on it doesn't legalize it. If it's illegal when it was installed, notwithstanding I bought it with that condition, it continues to be illegal. So to say that it was just because it was there when he bought it makes it legal is wrong as a matter of
I don't
law.
believe I'm saying that because I'm pointing out that it was there because there was a sense that he had recently constructed this. I do not say because it's pre-existing, it's legal. I don't say that. I'm making the
Well,
point.
then I'm not sure why it's relevant because the board finds that the stairway wells to be a pre-existing condition. What is that relevant to?
Relevant to all of the pressure that how come you did work without a permit? If it was a previous owner that did the work, that's very often remedied and you're allowed to have somebody come in and you get it rectified, but it's because there was quite a lot of information about how much work was done without permits.
Well, if the prior owner had done illegal work, that still has to be remedied. The fact that
I got it.
doesn't
I
make it
I'm fine.
unfit to be remedied.
I'm fine with
And
this.
we're
So
saying we don't have it. Let me continue. Then it says that the board finds that the 2020 decision does not support building inspector's determination that the walls need to be removed. Just the 2020 decision discussed the locked doors between the two unit, and it was part of the decision. Going on to the next one, again, rather than taking up more time, I will just finish. You all disagree with me. Rather than go through each of these in more detail, let me just make my comments and then we can vote. With respect to the number 8, the building inspector determination, share your kitchen and bath facilities and reside as a common household residence. This says the zoning code permits the applicant to share the premises with up to 2 roomers. The zoning code neither specifies nor prohibits the assignment of specific living space. The 2020 decision specifically determined that the use by the current tenant was not as a room or board. So what this resolution is essentially saying is that nothing has to, Mr. Teeker does not, notwithstanding that the board, notwithstanding that the board found that this was an illegal situation, the applicant does not have to do anything to remedy that illegal situation because each of these things doesn't make a difference and therefore he can keep them all. I think there's no question that this is overturning the prior decision. Not a little bit of a question. The fact that it's a pre-existing condition is irrelevant. We talked about the locked doors. We said it wasn't illegal. We said it wasn't a rumor or a border. You can't now say, oh, it is a rumor or a border. We said it wasn't a rumor or a border.
you did not say exactly that. You did not exactly say that. You said it was not akin to something. Why would you use a modifier like it's not akin to something? If it's not something, you say it's not something. It's not akin to something. What does that mean? And if, why would you put in akin if they are not a rumor or a border? Say they're not a rumor or a border.
Because they're not defined. So since they're not defined, it was impossible for the code for us to say they weren't. How do we know what a rumor or a border is? So we looked at other definitions and we could say it was an akin because we don't have a definition.
Right. And because of that, he should have known that. He should have been aware of that, and they should rip his walls out. I'm sorry. This is way out of my league. You guys decide what you want.
Exactly. And I think that, as I said, I think this is all overturning what the board decision, whether or not
I think this is embarrassing, not overturning.
Robin, it's in good faith. This is not overturning the decision. In good faith, we looked at it. The decision was vague. The decision at the very end didn't point to any particular critical issue, talked about totality of the circumstances, and really left it to the building department to make the determination. They made a determination and they overreached, and it was unacceptable. So now we're going back and giving some specific guidance in line with the original determination. And, you know, this determination doesn't just apply to 130 Beach Avenue. It applies to every single rumor and border situation, to all these Airbnbs, which, you know, may not even be legal anyway under the code, and everything else. And it gives very specific guidance so people can comply with the law. Simple as that.
I
think
think you're
this
giving
is
guidance.
very-
What we're
I think-
basically saying is, you don't have to do anything to do it. Just continue to do what you're doing. Everything you've done is okay. We're
Robin,
not we're not giving any guidance to the board or to any future operator as to what they have to do or what you can do. We're saying that you don't have to do anything. There is no guidance in here that was provided.
No, excuse me, may I? Robin, you're right. But you're giving, I don't agree with, but your guidance is you got tagged, rip out the walls and do all of that.
I haven't said what I think is appropriate. I'm saying that what this says is wrong. I don't know what I think is the right answer. I didn't even.
I know, but that's part of our responsibility, I think, with all respect.
Well, I think that since.
And I think it really is part of, and I think it's very clear. Why don't we move ahead? Let's continue, please.
Let's do it.
Okay, I would like to make an edit to my own finding in number 7. I would like to, instead of simply saying locks are only permitted, I would like to differentiate it to say hallway locks, hallway door locks, because there could be locks on safes or jewelry boxes or different things. So hallway locks are only permitted as would normally be permitted with any dwelling, and a hallway door lock, which is not key the same as other hallway door locks. Just that's what I would like to change it to hallway door locks.
Going back, we're just finishing up on the rumor or border, the board specific, what it says, it does not have separate housekeeping, and this talks only, it's interesting that this only talks about bath facilities, doesn't talk about kitchen in here, whether or rumor or border can have a completely separate kitchen of their own. I don't know it, but just, you know, this only talks about bath facilities. So it's kind of leaving that out. This one talks about the determination relates to kitchen and bath facilities, and yet the findings only relate to bath facilities. So
because it's responding to what the building inspector said.
Yes, he says kitchen and bath facilities. And yet,
okay, we could say he can share the kitchen facilities as well. But if he wants to eat all of his meals outside the space, he could do that too. He doesn't have to eat in the kitchen. If he goes to work and they give him lunch, or he just.
But he doesn't.
But that's fine. I don't care if you say.
A border does not have separate housekeeping facilities.
Right.
The bottom line, but you don't agree. You don't even say that. You don't say anything. All you say is you imply that. But since you don't say it, you're denying it, even though all you're talking about is bath facilities. Anyway, I think we should just vote on this rather than, because there's no point. You all disagree with me.
Really
I disagree with you. I think you should just vote. And let's move on. I do not think this resolution seeks to clarify the appropriate remedy since it currently has a non-portable stove or oven. Nevertheless, it was found to be a separate dwelling unit. And therefore, I don't think this is right since.
Robin, do you think that the building inspector, any part of it should be reversed or overturned?
You know what? I thought this was so overwhelmingly denying and negating what the resolution was. Do I think anything? Let's see, if I went through this and went through to answer your question, I would say, the 220 vote line. No, I don't think you have to remove the 220 vote line.
But the rest of it stays, right?
I don't know. I have to go through each of them now. I didn't do that.
Isn't that what we're supposed to be doing? Isn't that what this is all about?
But given that you have this draft resolution, given that all of you agree with what was found here, I didn't think it was necessary for me to have to go through each of these things, because we are voting on one resolution. I don't agree with this overall, so I'm going to vote against it, and therefore I didn't think it was necessary to go through. If you're asking me now to go through these,
No, I'm not asking you to do anything other than you've agreed to do as a member. That's all fine.
Yeah, I think that some of these may be overreaching. I do not agree that all of them are, as basically this seems to be saying. And I think that the way that a lot of this is worded is written in a way to completely overturn and negate the.
You keep saying that, but we had an appeal before us, okay? And the question I posed to you is, if you can't tell me, I mean, you're saying aside from the 220 volt.
But I just said there's no point, because you.
Well, that's not an answer. Then we would never have a debate. We could all just say, I don't
You want me to go? So I said I'll go through.
No, I don't want you to
And then
do
you moved
anything
on
that
and
you
you said
haven't
you don't
done.
need to.
No, it's 11 at night. I think it's very clear. That's
Right, that's what I wanted. That's what I said. Because
okay,
I'm not going to agree.
but it's
with them.
been months since this. Okay, I'm good.
I mean, there were other things that I might agree with were overruled or overreaching, or that could have been modified in a way to make it, rather than just grant the appeal. There are more things that could have been modified in a way, but that's not what we've done here.
You want a motion? Is that the idea?
I think somebody should make a motion to approve this.
Yeah, we know Charlie's doing his very best to transcribe what we are delivering to him. So I think we all know what it is that we're voting on. I just want that we have an opportunity that we vote on what we thought we told Charlie we wanted in it. Correct, Charlie? But what if one sentence was still there and we had said, no, we didn't want that sentence?
Do you want Charlie to revise it before we vote, and then we just?
No, I want to vote. I want to get past this. But if we could correct something, I don't know if there's some.
Well, no, I don't think
we always do that, Meg. Meg, we always, if we often vote with a draft resolution to which we've edited, and changes are made, and then we just review it and make sure that it is consistent with what we said. I don't think there's any reason this should be any different than that.
And I will provide a red line and a clean document so you can see the exact changes, Meg, that were made from your original document.
But we don't vote again then, correct? That's just
correct. We just,
right,
it's just
right,
like,
yeah,
it'd be just like any other resolution.
Right.
We vote on it like we already did tonight with respect to the one we just.
No problem, no problem.
419 Mamaroneck, we voted, there were changes. We'll just review it and make sure those changes are consistent.
Gotcha.
So I move to adopt the resolution that Meg drafted as amended in the discussion we had tonight.
I'll second.
Okay, so Meg.
Yes.
Greta.
Yes.
David.
Yes.
And I vote no. Okay, we are done.
And it's late. I think that's it.
No, we have one more application tonight.
I know, but it's 11:25.
I think we can, let's see if we can finish this last one up. If we can't, we won't. It is 504 the Parkway, and maybe we can't do 504 the Parkway tonight. Whatever the board wants, if you want to wait.
2 weeks, are we? We're meeting in 2 weeks?
Yeah, meeting in 2 weeks. Okay, so we'll leave 504 the Parkway for the next meeting? Yes, everybody?
I'm recused anyway.
Oh, right, you're recused. I always forget. But you're right. So, Meg, yeah. So Meg, you want to leave it you're okay with leaving for the next meeting? That's fine.
Yes. Yes.
Okay, so we will leave it for the next meeting, and we are, of course, adjourning the 416 Waverly Avenue. So,
I have a question on that. Just one quick question, please. That's on the Waverly, the FEIS?
Yeah, that's on the FEIS.
Yeah, I have a concern on that. I'd like to just pose, maybe council can deal with it. We can take it up at the next meeting, but there's been a recent storm in this community, and it was clearly, from my own visual appearance, it impacted this. And I'd like to know the impact of that, and I'd like it analyzed as part of any environmental impact study. Certainly, it's probably, we dealt with what if. Well, guess what? That's what happened last week. And I think you got to consider that. And I think the FEIS should be included in that. How long do we have to
Wait,
accept or reject?
my question, so I think the question for Charlie is, let's because it's a good question, David. The question for Charlie is, given where they are in the process,
Right.
can we at this point request and slash require them to excuse me, add additional do additional work with respect to the flooding issue? And that's the question.
Right. Well, I think it's our FEIS, if I'm right. And therefore, we can decide we want to address that. I certainly do. I'll bring that up at the next meeting. I think it's ridiculous not to.
There's no point in the process to make sure we have it. I will say one thing that I've spoken to Ashley about this. So apparently that's customary for them to, with the FEIS, to come back and just explain it. And that would be the appropriate time to make them, to ask them, I think, about this. But so they would come at a work session, or we would discuss it at a regular board meeting, but it wouldn't be a public hearing. It would just be like a presentation too. So it wouldn't be quite, it's not a public hearing in that we wouldn't take public comment, but they would be presenting the changes. So we would be doing, we'd have to set up the meeting to do it that way. But the question, Charlie, that Dave had asked is, can we at this point still ask them to make, to do additional studies based on the current flooding? And if so, is it appropriate to do now? Do we wait to it when they come to us for the FEIS, with the FEIS, you know, the kind of discussion of what it is, or when should and how should we do that?
Sure. So there's a legal answer and there's a practical answer. I'll start with the practical answer. I think it would be appropriate to allow me to reach out to the applicant's counsel to ask that they be prepared to address that answer. And I would imagine they would, for the record. You have two jurisdictional items before you where you can assess impacts: the area variance request and the secret review. If you review the FEIS, which is the final environmental impact statement that they submit, and you want to see something else in that final environmental impact statement, now is the time to ask for it.
Okay. Well, it's also our FEIS, isn't it? May I suggest that I would like to read it first? And it just came out yesterday, I guess. So
I haven't seen it yet. I did on a separate matter. I spoke with that applicant's law firm, and they did say that they had made a submission in the last few days, but I have not seen it.
And that's what Ashley,
the next meeting.
And that's what Ashley was talking about with me, which is the issue of they want to present the FEIS. So I guess the appropriate thing to do is for, I guess if now's the time. So should we wait until they present it? Should we just ask them now? It's not on the agenda, so I'm not quite sure if we can ask them now or what we have to do procedurally as a way to do it.
Why don't we have, if we could have a meeting with Charlie at the next meeting, if we could meet, because that might help. I think we should review what our responsibilities are, because as I understand it, it's our document. And
yeah, what you can do is, it is absolutely your document, but you can ask them to make draft revisions to it, and then you can review that before accepting it as your document.
I know, right? I understand that. All I'm saying to you is a very different thing. We didn't notice it to be discussed tonight. So the question I'm asking is procedurally, can we do it tonight, or should we notice it as something to be discussed for the next meeting and therefore ask them at that point? I'm just asking a very procedural question of what we should be doing.
Nope, it was on the agenda for this evening, so it's appropriate to discuss.
Well, it was only on the agenda to discuss, we adjourned the application. That's the application for the variance. It was not anything else about it. So I don't know that we can discuss it. It was only to adjourn it. So that's
the only thing.
You can still discuss it. You're in an open meeting.
Right.
Okay, so fine. Okay, that's fine. I just was checking. So David, do you want to formally make your request?
Yeah, I would know. I would really rather look at the proposal, because there may be other things. And I think then we can talk about it, and then we can make the request for them to come in if that's what they do.
Oh, so as I said, yes. So Ashley, it was explaining to me that what would normally happen is we would get a copy of the final EIS. The applicant would sort of present the final EIS so that we understand what they've changed. We understand what they've done. Given that, maybe that's the time to ask them to make these other changes.
Yes, but I'd like to be able to read it because there may be changes that based upon our review of it.
You're correct. I
So
understand.
I
But
think before they make a presentation, wouldn't it be helpful and logical for us to at least peruse it? And then when they come in, we can discuss.
that's fine. I was
I
thinking.
don't know, I'm
we-
asking, what's the
I'm
time
thinking they
limitation?
present it, then we'd review it based on their presentation. And then if we wanted changes, we'd make the changes. But we could do it either way. I just want,
I would
I mean, I
only-
could,
So you can ask now, you can ask at the meeting. I would only suggest that you allow me to reach out to the applicant to let them know that this question was asked. Because if additional work is needed to address that question, they can get started on it now.
I'd like to understand, I have not reviewed the FEIS in any way, shape, or form. I don't have a copy of it. But
because we haven't been circulating.
one thing I would look for in it would be an assessment of the storm impact, of what occurred, the nature of what occurred to the building that exists, as I understand it, the first roof, there's tremendous damage there, and the other lot too. I'd like to understand it, and I'd like it to be considered, because that is a result that has to be dealt with.
Yeah, I understand the request.
But I don't think, I guess listen, do what you want, and I'm not, I don't know, but my own personal preference is I'd rather, before somebody presents something, I'd rather be there, I'd rather have looked at something and then say, okay, here's my
Okay.
questions about it, as opposed to you're telling me what it says, which is very different.
Okay, so I will discuss with Ashley, assuming it was distributing the final EIS to the board members.
Yeah, she said that we could pick it up. I said, by the way, Charlie, if you could maybe send us the dates on this thing, how long everyone has to accept the FEIS or not? Are there time constraints and what have you?
There are time constraints. I'll send that around. I have a flow chart I
Super.
can send around. Those are oftentimes also waived by the applicant.
Okay. And what about we have a consultant on this as well, correct? They
Yeah,
should get a copy of this.
AKRF.
Yeah, they should get a copy of this, right?
Yep, they will.
Okay, super.
I think they actually already have a copy, but yes.
Good, thank you. All right. It is 11:50, no, 34. Oh, it's early. We have any more hearings?
Oh, bite your
11, I
tongue.
got
Bite
you.
your tongue, David.
All
No,
right.
don't. You just broke your tooth. So, okay, here we go.
Are we going to adjourn tonight?
So I think we're going to adjourn. Somebody want to make I move to adjourn. Is there a second?
A second.
Okay. Greta,
Yes.
David,
Yeah, sure.
Meg,
Yes.
and I vote yes. Good night, everyone. See you
All
in
right,
2
good night,
weeks.
everybody. Good night, Robin.
See you in 2 weeks.